The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Right, we will begin with Hun versus Bindi.
Thank you, Your Honor. May it please the court, Alex Buda on behalf of the petitioner, Mr. Huen. This petition presents two independent reasons for vacatur. First, the BIA required more than reasonable diligence. It discounted petitioner's actual efforts, retaining 3 lawyers, twice filing motions for post-conviction relief, and then acting promptly once removal became a real possibility, and instead faulted him for not continuously monitoring legal developments. That is not the standard this court announced in Williams, and it makes no sense under petitioner's unique circumstances where the government could not remove him. The board's contrary analysis reflects both legal error and a misreading of the record. Second, the BIA's sua sponte decision rests on a legal misunderstanding. It treated this as a routine case of newly available relief without engaging the distinct change in law argument that petitioner actually presented.
Can I ask you about the change in law? Your argument, as I read it, is based on 2 changes of law, right? Because there were 2 grounds at issue here. And in your brief, you say that after DiMaia, petitioner didn't have any rights to pursue yet. It wasn't until Belcher that he had any rights to pursue in reopening. Right, that's page 23 of your brief.
Yes, Your Honor.
But now that we have rejected petitioner's Belcher arguments in Perdomo Ulloa, does the petitioner now again have no rights to pursue in reopening?
No, Your Honor. So to be clear, I think the right way to think about this question about how Perdomo impacts this case is whether this case is now moot or whether remand would be futile. And the answer to both of those is definitely no. Petitioner has a viable pathway to relief through adjustment of status if the agency grants him an inadmissibility waiver. That waiver is discretionary. This was the alternative argument.
Is that part of the reopening? Is that part of what was in front of the agency before and is in front of us now?
Yes, Your Honor. So the principal argument in the motion to reopen was that he was no longer removable because both charges were no longer valid due to the changes in law. We acknowledge that after Perdomo, he remains removable on CIMT grounds. So this case is now about the alternative request for relief, which was adjustment of status with the grant of a discretionary waiver.
Can I just ask you about how that doubles back to what Judge Rushing said? So the idea is that even though your second argument now doesn't work, you argue that there's still real things at stake for your client because even if your second argument doesn't work, there are things that he could still get. But that suggests that he had an argument after DiMaia. Like, I don't know how you can get the horns of the dilemma of, like, if the argument is the reason he didn't need to do something more shortly after DiMaia was because there's nothing to do, but they're like, well, but now that that second thing doesn't apply anymore, he still has an argument. That suggests he had an argument. Maybe not the full argument, maybe not the best argument, maybe not the most thing he wanted, but this seems to be a paradox in that to me.
I appreciate that, Your Honor. And I think that, it's important to remember that when we brief this case under a completely different legal landscape, and there is a significant difference between someone who cannot be removed from the country at all versus someone who has a pathway to relief through a discretionary waiver. So I appreciate that. I appreciate that our argument that he didn't have any rights to pursue after Belcher, it reads quite stale now. But the point is that the question for this court now is, after Perdomo, what does the court have to do in this case? And my argument is simply that there's no way this case can be moot because he has a concrete pathway to relief here. And the only way he can get that relief is by getting the board to grant his motion to
So just to
reopen.
clarify, though, is that pathway to relief was available before Belcher was decided?
It was, Your Honor, yes, it was.
Okay, and so the BIA, when it assessed diligence without mentioning Belcher, that's all relevant now. It's not an improper review at this point.
So I appreciate the question. I think the answer is that the board still did err when it completely disregarded his Belcher argument because the board did not address the argument that petitioner actually presented. This court has held that is a legal error.
But that doesn't matter now, right? The Supreme Court tells us if the agency
Right.
would be required to reach a certain outcome on that point, then we can.
Sure, so I appreciate that, yes, Your Honor. So I appreciate that the import of that legal error is no longer here because of Perdomo. So, but the point though remains that the board still erred in denying diligence and in denying his sua sponte reopening request under the wrong understanding of his motion. And now we still think that the board, we still need a remand so that the board can reassess those questions under the correct legal understanding, and because that's his only pathway to get reopening and to ask the agency for a discretionary waiver so that he can adjust status.
Concerns me that the delays in this case were a matter of years. No matter what order, BIA order you're talking about, even after DeMaio, which came down in 2018, Belcher 2022, you still waited years to file a motion to reopen. In that, you're asking us to excuse a rather long period of delay.
So, Your Honor, I think this case is unique, and because there are two unique circumstances, and I kind of want to disentangle those a little bit more so than we did in our brief. So, the first is that the petitioner took significant action right after he was ordered removed. He hired a lawyer to seek post-conviction relief in 2005. That lawyer actually obtained the prosecutor's.
You say he took significant action, but isn't the only significant action for our purposes when the motion to reopen was filed?
No, Your Honor. So I think the point that I'm making is that the context before petitioner had rights to pursue after DeMaio is enormously important to understanding what reasonable diligence looks like once he gets rights after DeMaio. So the point I'm making is that, after he was ordered removed, petitioner hired two different lawyers who sought post-conviction relief. They actually filed motions, and the board completely disregarded this evidence, which we think is a legal error. So he hired two lawyers who unsuccessfully pursued post-conviction relief.
But even coming into the present, I mean, what rights would DeMaio and Belcher give you? Because the matter of a ruse, it wasn't even part of the statute of conviction. Ruse didn't play into the statute of conviction. And then when you look at Belcher, it's clear from our opinion in Ulloa that 12 months or one year or whatever, that all of these periods of time are the same. They're not a year and a day or a year or whatever. They're not distinct from one another, but at the end of the day, I'm just not sure what either DeMaio or Belcher gives you. I mean, what rights are left?
Yes, Your Honor. So we contend that petitioner is no longer removable as an aggravated felon after DeMaio. We think that's actually quite a straightforward application of the categorical approach to the statute, and I appreciate that ruse was not in the statute, but I don't think that makes any difference to the categorical approach analysis. But I want to be clear that this court does not have to grapple with any of those questions, because those are questions for the agency in the first instance, and the BIA did not even reach any of that. So the BIA denied simply on diligence grounds. That is the central issue before the court today. We don't think the court has any reason to address any of those questions, but I would contend that it's quite a straightforward analysis that he's no longer an aggravated felon after DiMaia.
Can I ask you about what just strikes me again, now that we're in the world we're in, and I appreciate that when you wrote the briefs, the things were different. So let's change one fact. Let's imagine that counterfactually, your client had sought relief pretty immediately after DiMaia, had filed for reopening almost immediately after DiMaia, right? And the board denied it at that point, like right after DiMaia. Am I correct that he would clearly be time and number barred in that situation? Now, if he tried to do it again now, he'd be both time and number barred?
Yes.
So doesn't it seem a little strange that under your argument, he is better off because he didn't file right after DiMaia than if he had filed right after DiMaia?
Well, Your Honor, I would contend that it would be quite a difficult, the government would have a much more difficult case in your hypothetical of defending the denial back in
Oh, no, that's gone. That's over. Like, he does it in the immediate aftermath of DiMaia, and people at the time haven't really thought through the implications of DiMaia, so it's barred. So we add that fact,
Sure.
and then we keep everything else about the case the same, and you're here in the same posture from the same denial of the motion to reopen. But in this situation, the BIA says, what are you talking about? Your time and number barred now. And we're reviewing a petition for review for the BIA saying your time and number barred.
I don't think that would change the analysis today. We would still be making the same equitable tolling analysis, because equitable tolling can overcome both time and number.
Well, I don't think that person could have made an equitable tolling analysis because that person filed right after DiMaia. They would, you know what I'm saying? They're just trying to do it again.
Yeah, I understand, Your Honor. I think there's no different. I think the analysis would be exactly the same today, because we would still be seeking equitable tolling because of the number bar in your hypothetical. I don't think that really changes where we are today or what the analysis would look like. But to go back to the diligence issue, you know, I think there are two unique circumstances here. I've already touched upon his actual efforts. And I want to be clear that other circuits have held that on its own is sufficient to warrant not taking further action until there's a good reason to do so. So the Sixth Circuit in Gordillo says, you know, when a petitioner gets advice from multiple lawyers who all tell them the same thing, you know, there's no reason to question that until you have a reason to. And in Gordillo, it was the person was apprehended by ICE several years later. And then also in this case, we have the unique circumstance of where the government could not remove petitioner. And he experienced that firsthand. In 2007, he was detained by ICE. The government couldn't remove him. They had to release him. And all of his lawyers, all three, correctly told him that there's nothing that you practically need to do because the government can't remove you.
Could I ask you I just go a question about comparison between this case and Williams?
Sure.
So let me offer, I think the government makes these, the following differences between this case and Williams, and this even assumes that Belcher is even relevant at this point. So as I understand it, the differences between this case and Williams are, it's at least a year longer in this case than it was in Williams, right?
Yes.
Unlike in Williams, your client was in the United States, not in Jamaica, right?
Right.
So why don't those two things matter?
And your client has access to more funds than the client in Williams.
Sure. So I don't
Has
think.
his family around him to help and support him.
Yes,
There are
Your
a number of
Honor.
factors.
Judge Wilkinson, I see I'm out of time. May I answer the questions?
You may answer the question briefly.
Yes, Your Honor, thank you. So I don't think those distinctions matter. First, the distinction about him being in the United States versus abroad, I actually think that distinction helps us. In Williams, you know, Williams from the day he was removed was inadmissible and could not return to the United States to see his children. And for 12 years, he admittedly, this is in the record, Williams did absolutely nothing. And the court excused that, or, you know, the court said that was reasonable under the circumstances to not continuously hire a lawyer throughout those 12 years because of his financial circumstances. And I appreciate that there is, you know, some differences between the financial circumstances here and in Williams, but I don't think there's much daylight there. I think, you know, the record here is clear that that petitioner only has an income of about $40,000 a year. That's at JA 221. There's actually a continuous motion at JA 580 where petitioner told his lawyer during removal proceedings that he didn't actually want
Right,
to
counsel.
file a brief. Sorry, my last point. He didn't want to file a brief on the key issue, whether he was an aggravated felon, because he could not afford it. Thank you.
Thank you, counsel.
Thank you.
Silence.
Good morning, Your Honors. Rodolfo Saenz for the U.S. Attorney General. This court should deny the petition for review for the reasons based in briefing.
Can I ask you about extraordinary circumstances?
Sure.
The argument here is that a change in decisional law removed an extraordinary circumstance that stood in the way of filing within 90 days, right? And that was the argument in Williams and these other cases, that the law changed 10, 20 years later, and that qualifies as an extraordinary circumstance that should toll the time.
Correct.
The BIA has held that, I presume, and the government supports that theory?
I hesitate to answer yes in terms of the board, just because I'm not familiar with an exact case, but this court has held that.
Yeah, it just strikes me that it leads to these sorts of very strange arguments where we are comparing, Mr. Williams from a previous case and this case, and we're asking the question, how often do we expect a reasonable person who has been ordered removed from this country to be checking in with an attorney about whether the law might have changed, right? That doesn't seem reasonable really ever, but we end up in these bizarre situations where we're comparing, well, are you so rich that we expected you to be checking with an attorney all the time? Or was your situation so hopeless that we expect you never to check with an attorney? It seems like the root of the problem might be that a change in decisional law is not an exceptional circumstance, doesn't it?
I don't want to give a blanket rule because there could be, depending on the facts of a case, a different scenario where it might be. But I think Your Honor raises an important distinction between beliefs about the likelihood of being removable, which is what is being argued in this case, and the complete impossibility of removal.
Well, how about the impossibility that we weren't removing people to Vietnam?
Well, that fact is not in the record, Your Honor, and this court's limited to...
You're here on behalf of the United States government. Presumably you are prepared to represent when the government was removing people to Vietnam or not, right?
It doesn't seem entirely clear to me, Your Honor.
You're not prepared to address his repeated assertions that I didn't think I was going to get removed because the federal government was removing no one to Vietnam for years?
Our position would be that
I'm not asking your position. I'm asking you if you were prepared to represent whether or not the federal, or to dispute his repeated assertions in his brief, which he asserts over and over again. I know you've read his brief. Are you disputing his assertions that the United States was not removing people like him to Vietnam?
In his brief, and he drops a footnote to certain articles...
I cannot believe that, I was a federal government attorney. I cannot believe that you are not prepared to answer a factual assertion about what the executive branch was doing.
Let me answer it. So in 2008, there was a repatriation agreement that allowed some individuals...
And
from
he
Vietnam
asserts that
to
under
leave.
that you can't remove someone like me.
In any event, it doesn't matter, Your
So
Honor.
you're not, wait, again, you are not prepared to address, he makes this assertion. You are not prepared to say whether he's lying when he says that?
Admittedly, Your Honor, I do not know the exact...
So you cannot represent when the United States government decided to start removing individuals like this individual to Vietnam. It's the cornerstone of his argument. The reason I didn't think I needed to do anything is because my attorneys repeatedly told me that someone like me is never getting removed to Vietnam.
I did reach out to DHS counsel to find out when they did...
And they just didn't answer you?
Sorry?
They just didn't answer you?
They informed me that they're currently removing individuals.
No one's arguing that. The question is when. His whole argument is, it was reasonable for me to not worry particularly about getting removed to Vietnam because the executive branch was not removing anyone like me to Vietnam.
Anyone like him, but other individuals, sure.
Who cares about other individuals? If I'm him, I care about me.
But there's still no factual nexus between that reality and this person in particular, whether it was believed by that person informing the decision.
I'm going to give you one more chance to answer my question. Do you know, or are you prepared to controvert his assertions about when the federal government started removing people like this individual to Vietnam?
I'm not sure, Your Honor. No, I cannot answer that.
Could you please look into it and submit an update? Because at least I think that's relevant.
Sure, I'm happy to do so.
What difference does it, what present practical difference does this make at this point? Because it seems to me that the two decisions that your opposing counsel rests on, DeMaia and Belcher or whatever, and I don't understand at this point what rights are left. I mean, we're going to hold that the board abused its discretion in not reopening, but in light of the fact that ruse was not a part of the statute of conviction, it would seem to take DeMaia out of play, and the Belcher in our recent decision in Uloa indicates that, that these distinctions that he wishes to draw are simply unavailing. So what practically are we left with? And the opposing counsel says we don't need to get into the merits, but I certainly wonder, what lies ahead. You're going to say the board abused its discretion, but there's no there.
I agree, Your Honor. The only argument that was made in the opening brief was the one about ruse, and as it was discussed earlier, that it was beyond the scope of the statute of conviction, so that takes that out. I think opposing counsel was arguing that there could be a possibility for a waiver to adjustment, because for adjustment you need to be admissible. So if there's no dispute that he's inadmissible with the CIMT, he needs a waiver in order to show that
does the sheer length of time and the length of delay in moving to reopen, does that matter? This is to say that the petitioner that the board abused its discretion or whatever, in the face of years-long delays in moving to reopen, what kind of precedent does that set? That there's an abuse of discretion despite the fact of, extraordinary delays. I mean, sometimes things are matters of degree. And we're not talking about a day or a week or some sort of arbitrary tripwire. We're talking about years.
Correct, Your Honor, and I think the result would be that there would be an incentivization to delay or to reward behavior.
Okay, I'm as sure as I can be of anything that you think that Williams was deeply mistaken, but you understand that that is a panel decision of this court, right?
Yes, Your Honor.
Okay, so Williams says changes in law can be can cover blah, blah, blah. So I'd like you to tell, you believe that what this individual did isn't diligence, right?
Correct.
What would have been reasonable diligence in your view?
Keeping
in mind that we are bound by Williams, so you can't give me an answer that says Williams is wrong.
Sure. I think it's important to look to an important fact here, that in 2010, at the last juncture that he interacted with counsel in terms of sentencing modification, the sentencing modification indicates that he was advised that he was on the list to be deported. That was the last interaction he had with counsel. So it refutes the belief that he was unable to be removed at that point.
That is not the basis on which the BIA denied relief in this case, right?
Correct.
Okay, so how about we try with something that fits sort of with what the BIA actually said?
Sure. Well, as the BIA said, there's no evidence of any action being taking place between DeMai in 2018 and...
But that's sheer time, and now you run straight into things like the Sixth Circuit's decision in Gordillo, this court's decision in Williams. Like, you're just like, it's too darn long, it's too darn long, it's too darn long. I can cite cases that, in fact, Judge Kethledge, I thought, just explains very well. It's too darn long, standing alone in and of itself does not refute a finding of diligence, right? Surely you're familiar with the Sixth Circuit's decision in Gordillo.
Yes. And
Which says very clearly, mere length of time alone is never sufficient.
Right, but it was in the ineffective assistance of counsel, and in Williams, this context, and in Williams, this court distinguished between ineffective assistance of counsel and changes of the law. Those two situations require different applications of law. There's
Okay,
different
but so
standards.
now, but I don't think that changes the prospect that, oh, so your view is that in this context there is a it's just too darn long exception? That you think standing alone, the sheer length of time by itself can be sufficient?
That's what Lawrence said, that the length of time is an important consideration.
Important consideration is not like when you say something's an important consideration, that's not to say that it standing alone is sufficient.
Sure, but there's a 7-year gap of no action. That's based on the record. And then there's contradictory evidence as to what the belief of removability was prior to that, 10 years before that, when he was interacting with counsel and trying to do something with his case. I do think it's important to reiterate some factual distinctions in the record also about 2004 and 2007 and 2010, which is what is being relied on here to speculate about what was believed between 2018 and 2025. In 2005, he filed another sentence modification motion, which contained the exact same language in the 2010 that he had been advised that he was on the deportation list. After that sentence modification motion was unsuccessful, his counsel at the time sent him a letter that indicated that, or recommended that he might try to dispute that he has a CIMT. And it was forlorn that there couldn't be much more to do about stopping his deportation. So we have other evidence in the record, and I'm happy to point the
So
court.
wait, now we're back to, again, a prediction about whether we're going to remove this individual to Vietnam in a case where you can't literally tell me whether the government was removing people to Vietnam?
Correct, Your Honor.
I just feel
But
like this feels like a really important part of your argument. I mean, I am genuinely flabbergasted that you can't answer that question.
But it doesn't matter because we know nothing about his beliefs and what he was thinking during that time period. And all we know is that he took no action during that time, and we're speculating about his beliefs based on
We're
what
speculating
he was told.
based on what he's told us? It's speculation to take a person's word for their own, their explanation for their own behavior?
There's nothing in the record itself that he believed that he could not be removed because of the government's not coming to an agreement about whether or not they could remove people to Vietnam.
Other than the documents he's filed asserting that?
Other than which documents?
You know, his filings in this case in which he asserts that?
Correct. The assertions of counsel.
So you think he needed like a verified affidavit or something? Or maybe a hearing? A hearing is one way we could find out what he believed and when and why.
In 2010, he had been advised that he could be deported. The least we could expect him to do is to inquire whether that's actually the case again. But we don't have evidence of any action being taken between 2010
So what
and
about all the cases
2025?
in his 28J letter, he cites all these cases that says one of the things that's about, you know, it's reasonable to expect that an individual began to take action to challenge removability once that individual learns they are removed to a country and they're like, why doesn't that logic apply here? The argument that's made in his 28J, why do those cases not just squarely apply here?
Sure. It was, again, in the ineffective assistance
All right,
of
I just pulled
counsel.
up Gordillo, and I do not think that is a fair description of Gordillo. They talk about ineffective assistance of counsel, but where they talk about diligence is not in the IAC section of that opinion, as I read it.
Okay, that's a fair distinction.
That's a pretty important distinction, because that's what you said in response to my question about Gordillo.
Yes.
So, okay, so taking that off the table, how do you distinguish Gordillo?
I think here there's a longer period of time that passed between when counsels had been involved with the petitioner and made representations to him, and here where there was at least a 10-year gap before DeMaia even came out. So our position would be that there's a different record in terms of the length of time, and there's also a difference in terms of what was believed and done after the fact that there was an extraordinary circumstance that changed things.
Normal civil litigation, if the advice that counsel makes or the strategic decisions that counsel makes or whatever, even if they turn out to be erroneous, they're still charged to the client. And how does that principle figure here? At what point are counsel's advice even bad advice? It still is charged to the client. Normally, that's the case. It's certainly subject to an ineffective assistance of counsel claim. But I worry about having we seem to be moving more and more to special protections in the immigration context that are above and beyond the protections that we allow in normal civil litigation. So at what point does counsel's decision, even an erroneous decision or a bad decision, at what point does that become chargeable to petitioner under the normal rules of lawyer-client relationships?
Agreed, Your Honor, that it's definitely not indefinite, but we have the guidepost here from Williams and Lawrence. Williams said a year of waiting was reasonable. Lawrence said that 2 years after change in law was unreasonable. So we have a general idea of how much time that could be. I hesitate to draw a specific line, but here we have 7 years, which should be more than enough inaction to start to see that there should have been a minimal effort to be made to see if there's anything that can be done for the case, or if there's something that has changed in terms of the policies that DHS has about removability.
We're in a situation in many of these immigration cases where the strategy is simply to delay, in the hopes that some favorable decision will come along. Delay is looked upon as a valuable strategy, regardless of whether the delay is well-founded or not. But the whole idea is to, in these immigration cases, is just to string it out and delay it and delay it and delay it. And lawyers have every incentive to do that, because particularly if we say that there's equitable tolling here, I'm wondering if we're not increasing or feeding into this whole situation where delay is a vital and acceptable part of dealing with the courts. And you look at what's happening at the Supreme Court and what's happening with Congress, and they're shortening limitations periods. And you have many decisions like McKinn and others which say these deportation proceedings should proceed efficiently, but if we allow equitable tolling for very, very long periods of time, you get the idea that the courts are moving in one direction and Congress and the Supreme Court are moving in a different direction. And what do we do with that? What do we do with that? Because there's no mistaking when you look at the Supreme Court decisions and you look at the congressional enactments, and you look at the federal rules, and Rule 26 says it has to be specific authorization in a statutory limitations period in order to extend the time. And it just seems to me that Congress is trying to say this has got to move efficiently. Whether we like it or not, the language of these statutes, they say they must be filed within a certain amount of time. They must be. And then you look at the federal rules, and they say, well, in order to extend that time, there has to be specific authorization under law. And it's clear that Congress and the Supreme Court are trying mightily to have these proceedings not drag on indefinitely.
I see I'm out of time, Your Honor.
All I'm asking is, are we in danger of establishing a serious riptide to the trend that the Supreme Court and Congress are to what they're very intent on doing? You understand what I'm saying?
Definitely, Your Honor, and I think
So is the reason this individual hasn't been removed for years because he's been filing and obtaining stay after stay, or because the federal government hasn't removed him?
it's unclear.
Really? He's been checking in with immigration for years. This does not sound like a case where the reason it's been going on so long is because he's been dragging his feet, right?
That goes back to, I think, the distinction between beliefs about the possibility and
The
just
government made no
impossibility.
action whatsoever to remove this individual for this entire time, and as soon as he was picked up in immigration detention, he tried to reopen, right?
Correct.
So it's not his fault we've been here this long, is it?
In that regard, yes, Your Honor.
This is not a death row inmate who's filing appeal after appeal after appeal, right?
Right, but he knew that he had a removal order, and the removal order was still active. And so I think the burden would be on him to show that there was something to do about that removal order and to get rid of that danger of possibility, however so small. Just to answer quickly Judge Wilkinson's question, if I may, I think it's helpful to look at Judge Rushing's dissent in Williams, which said that the whole purpose of diligence can be swallowed.
Wait, we're interpreting this court's binding case law in light of what dissent said now?
No, I'm just citing persuasive reasoning, Your Honor.
Dissents aren't persuasive. By definition, dissents are dissents.
I mean, we could differ on whether the dissent is persuasive reasoning. Thank
Correct.
you for your argument.
Thank you.
The other thing is, I just want to point out, in terms of the government's action, the removal order is still out there. Now, I'm just not sure that if the government has not moved to enforce the removal order, I'm just not sure that sets in motion equitable tolling, because the removal order is there. And if you don't like it, and then they have every incentive in the world to try to get that removal order taken away and resolved. And whether the government seeks to enforce it or not, it doesn't change the underlying fact that the removal order is there. It's in petitioner's interest to get that removal order overturned. And whether the government tries to enforce it or whether it doesn't enforce it, the order is still there. And the burden lies on petitioner to get it overturned.
And equitable tolling is an extraordinary remedy. It's supposed to be used sparingly. So I think that's an important closing remark.
Yeah, thank you.
Thank you.
Mr. Buda, you have some rebuttal time, sir.
Thank you, Your Honor. If I might just pick up that point where Your Honor was going, this case is quite different than the ordinary case where the government is simply not, is exercising its discretion not to remove him. The government tried to remove him in 2007. It detained him. It could not remove him. And so after that, after experiencing that, petitioner reasonably understood that there was nothing the government could actually do to remove him. And I want to be clear that the record is clear. There is a basis in the record for his understanding that the government could not remove him. He explains in his affidavit at JA 262 that he is annually checking in with ICE. So every year he's going to the government is telling him, hey, good to see you. We can't remove you. And so he's going about his life, and that's the perfectly reasonable thing to do in those
Can
circumstances.
I ask you about the period of diligence that we assess? I thought the argument from your brief was that consistent with our case law, we look at when the exceptional circumstance was removed, and we look at the diligence from then until he moved to reopen. Is that right? You were faulting the board for looking from DeMaia to reopening. You think they should look from Belcher to reopening?
Yes, Your Honor.
So what did he do in that period? It seemed like it was more than 2 years of doing nothing.
Yes, Your Honor. So
If we look from Belcher to when he moved to reopen.
that's right, Your Honor. The point we are making is that the context of everything that happened before that period of time is what makes is what explains. It all comes down to the context.
Yeah, I understand that. It's just, I want to keep our perspective on that the question before us is reasonable diligence.
Right.
And in some cases, someone might have done something, and we're assessing, was the thing they did reasonable diligence? You know, they tried this, they tried that, they asked for advice, they got bad advice, but was that reasonable diligence? But instead, here we have more than 2 years of just nothing. So we're assessing, was doing nothing reasonable diligence for over almost 2.5 years?
So, Your
And
Honor,
we're comparing the nothing he did for 2.5 years to the nothing Mr. Williams did for 1 year, to see which one is more reasonable.
So, Your Honor, the reasonableness of what diligence looks like once someone has rights to pursue has to be informed by the context of what happened before they had rights to
Right,
pursue.
sure.
Yeah,
There's not much to
compare.
There's not much to look at, right?
Sure.
Diligence, reasonable diligence implies something, some diligence, that there is a standard of, we require you to do something, and we will assess whether that was reasonable. But to have nothing to go on, right? That the petitioner did nothing for 2 years, doesn't, I take your point that we have to understand why and look at the history, but that would seem to suggest that in every case, doing nothing is fine, and that's reasonable diligence because, well, we couldn't expect you to be doing anything.
So we certainly don't think that it's in every case reasonable to do nothing for the period of time that you have rights. We think this is a very unique case where that's reasonable, and that's only informed by the context here. And to just
Can you walk what the context is, including his illness that you talk about in the brief?
Yes, Your Honor. So the context that we think informs his diligence is this: he hired 2 lawyers who unsuccessfully pursued post-conviction relief. He hired an attorney when the government detained him in 2007 and could not detain him. All 3 of those lawyers told him, there's nothing more you practically need to do because the government cannot remove you. And by the way, there's also no path to relief at the time, and that was accurate advice at the time.
So the argument is there's an order of removal. The government has ordered you to leave the country, but they probably can't do anything about it, so you don't need to leave.
Well, it's not that they probably can't do anything about it.
They can't enforce it, right? They've
Right.
ordered you to leave, but, come and make me.
They cannot enforce it. And I just want to be clear, there's no meaningful consequences to that for petitioner because he's has a work permit to work lawfully in the United States, and he has nowhere to go. So there are really no meaning. He had no reason to act until the government detained him. And the through line in these cases that we cite, in the Sixth Circuit's decision in Gordillo, the Ninth Circuit's decision in Esquillian, the through line in those decisions is that in these unique cases where the government either can't remove you or you've tried repeatedly to pursue relief and you're unsuccessful, the through line is that the key moment becomes when there's a reason to act again. In Gordillo, the reason was because ICE detained the petitioner. In Esquillian, it was because the government said, Armenia is now accepting people like you and we can remove you. And in this case, it's when the government detains him in 2025. And as soon as the government does that, he promptly retains a lawyer who files a motion to reopen just over a month later, even
So
though
it's
he's
not really,
detained.
it's not really the change in law that's doing the tolling, it's the government's inability to enforce its removal order that's doing the tolling.
That is explaining why that course of action is reasonable, which is the inquiry for the tolling. Yes, Your
There's
Honor.
some danger here of turning everything on its head because we've normally accorded a great deal of discretion to the BIA in terms of whether it allows, whether it declines to reopen. And we say that the board's due a great deal of deference in whether it decides to reopen or not. And we seem to lose sight of that. And it's also his burden to overturn, and we seem to be sort of shifting that. And I think both in terms of the burden to overturn and the standard of review, we're kind of turning those on this decision kind of runs the risk of turning those basic rules of respect for the board's discretion and acknowledgement that the burden in the final analysis lies with someone facing an order of removal to take every step possible to overturn it. And yet both in the question of whose burden it is and what the standard of review is, we seem to get farther and farther and farther away from it. That's part of the problem here. It seems to me.
Your Honor, I see I'm out of time. May I briefly respond?
Do you have something to say that you haven't said before?
Yes, Your Honor. So I agree that the board has enormous discretion here whether it ultimately wants to grant relief. And that is precisely why we want a remand, is to ask the agency for a discretionary waiver. That analysis is much different now after DeMaio. So we would ask this court to remand so that the agency can weigh the equities here and exercise its discretion against the correct legal
Well,
backdrop.
thank you, and I see that
Thank you.
you took this case pro bono, and we very much appreciate you doing so. And certainly there's been no lack of due diligence on your part.
Thank you.
So
Thank you, Your Honor.
we thank you. All right, we're going to come down and recounsel, and we will recess court and reconstitute the panel.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. All right, we are here to address the Demarkian case, and Mr. Hughes, when you're ready, we'd be pleased to hear from you.
Thank you. Good morning, Your Honors. May it please the Court. Matthew Hughes for Demark Advisor. The District Court's latest injunction is extraterritorial in violation of Abitron, and Demarkian conceded that expressly in their briefing in the Millen appeal that this Court will hear argument on later this morning. That injunction has other problems. For instance, paragraph 3 of the decretals, the District Court subbed out the copyright claim, which it dismissed at summary judgment, for a trade secret claim in support, without adequate explanation or analysis. The corrections order blatantly compels speech in violation of the First Amendment.
What's your jurisdictional basis for us to even hear this correctional order or the contempt order?
Well, we've raised a number of arguments. I think it's an injunction. It gives clear instructions, a deadline, threatened sanctions for not.
And the contempt order are injunctions?
The corrections order is an injunction. We think that the contempt order contains an injunction with respect to Mr. Millen, but it's not just an injunction.
I thought there was a separate injunction ruling.
There is. So there's the Second Amendment preliminary
two
injunction.
injunctions.
That's what we argue, yes. And even if
I
it,
understand what you argue, but you need to get around Bestwall.
well, Your Honor, there's the factors, the characteristics of an injunction that Woody set out. Specific instructions, here's what you need to do, a deadline, and the corrections order had a deadline. In fact, it wasn't many days from the date that the order was issued. And it threatened contempt and sanctions for noncompliance. All those things are present in the corrections order. But it's also a collateral order. It's not tied to the merits of the case because it's...
This corrections order, just so I'm not confused on it, wasn't that an order entered in response to the Supreme Court's case?
No, Your Honor. So there's 3 orders, right? There's the Second Amendment preliminary injunction.
Right.
There's the contempt and sanctions order. And the corrections order preceded all of those. Alleged violations of the corrections order led to the contempt and sanctions. The corrections order had nothing to do with Abitron, correct? The modifications to the Second Amendment preliminary injunction were in response to Abitron. The corrections order was issued before Abitron came out. And again, we think that it's a collateral order. It's about whether or not Mr. Millen and Demark Advisor lied. It's not about the underlying merits. And it's effectively unreviewable. I mean, these orders that the district court has entered are poisoning the minds of the Dutch court, and only immediate vindication on appeal can correct that. If it's allowed to continue through the end of the case, it's going to have massive effects, and the toothpaste can't be put back in the tube.
Okay, but where is the irreparable harm in the sense, with regard to the order, ordering the corrections, didn't you agree to hold in abeyance the matter for what, 1 year?
The appeal.
Yeah, right. I mean, you agreed to the delay. What is the irreparable harm that would occur if that were not addressed in the regular course of business at the conclusion of the judgment?
I think, Your Honor, the problem here is that the contempt and sanctions order play into each other. And as far as the corrections order is concerned, a lot of the damage was already done as soon as the order was issued. It had a really tight deadline for compliance. The deadline to appeal didn't pass until after that. But even so, there's pendant appellate jurisdiction because it's tied up with the Second Amendment preliminary injunction, which we've challenged on extraterritoriality.
Right,
grounds.
but you still haven't addressed the issue of the irreparable harm.
It's true, Your Honor, that I think the right explanation for that is that the Dutch proceedings were stayed shortly thereafter.
Right,
So a
they've been stayed.
substantial portion of that period,
Yeah.
the Dutch proceedings were stayed. We've asked repeatedly that they be put back into, practice. And so I think that ties into it. But even if it's not a collateral order, there's pendent appellate jurisdiction, because the extraterritoriality issues surrounding Mr. Millen's affidavit are directly tied into the extraterritoriality issues in the second amended preliminary injunction.
But the Dutch litigation has already been stayed.
It
I
has.
mean, so that makes the showing of irreparable harm in terms of the correction order a difficult showing for you to make in light of the fact that the Dutch litigation has been stayed.
That's actually part of the harm, because the Dutch court only stayed this litigation.
What is part of the harm?
The fact that the Dutch litigation has been stayed and isn't resuming. The Dutch court stayed the Dutch proceedings because of a copy of the corrections order that was provided to the Dutch court. So the Dutch litigation can't get going until the district court's errors that we're complaining of are reversed or vacated. And the inability of those proceedings to proceed in a timely manner, because the Dutch court is confused about all of the district court's mistakes. But turning to the merits of the
I
injunction.
don't understand what you mean. The Dutch court has essentially stayed its proceedings because, in line with its Article 12, it's now determined that the merits of this case proceeded before its case.
It only did that after the
Regardless
district.
of what it did, that's what it's doing. It's now stayed the proceeding there. You're now seeing there are errors here in the determination of whether this proceeding here in the United States preceded the one in the Dutch court, so the Dutch court can go. But I don't understand where you're going with it in answer to Judge Wilkinson's question.
My answer is the only reason the Dutch court stayed the litigation is because of the district court's correction order, a copy of which was provided to the Dutch court. That order was erroneous and mistaken for all the reasons we've alleged.
What were the errors? Because the question is, when did the merits of this case in the United States started? Is there any question that it started under the federal law at the time the complaint was filed?
There's no question about that under U.S. law. But the question for the Dutch court is, what is Article 12 of the Dutch procedural
See,
code?
that's where I got it. That's where you're going. You want to take and say, under Article 12 of the Dutch law, they have a procedure under Dutch courts that they follow, and when you look at another country, you got to use the procedure in Dutch court. But that doesn't make any sense if the Dutch law is meant to say, we will not start with merits if someone else has started with merit. So if the merits start in the United States for purposes of Article 12, that's what that means. And that's what the Dutch court knew, and that's the order it entered. It knew this. It knew just what you just said. And it could have said, no, we're not going to pay attention to what's going on in the United States. We're going to follow Article 12 in our procedure. But the Dutch court chose to follow that procedure to say, which makes sense, doesn't it?
Your Honor, the Dutch court only reversed course on that issue because of the district court basically trying to tell the Dutch court, here's what you should base your ruling on.
I know,
And
the
that
district
was
court only
error.
told it that when the merits of this action started in the United States.
So
And you say it started at the filing of the complaint, which is before the Dutch action. So what's incorrect?
what's incorrect about it is that under Dutch law, the U.S. proceedings didn't get to the merit stage until after the Dutch complaint was filed. So what the equivalence is for merits purposes, that's a question of Dutch law.
You think the Dutch court didn't know that?
The Dutch court knew it and
But it
understood
chose
it.
to follow that line of reasoning. The Dutch court, you're saying the Dutch court is mistaken because it should follow its own law as opposed to the United States law. Is that your proposition?
Not quite. What I'm saying is, originally, Mr. Mayboom's pleading notes laid this all out very clearly. Here's when the complaint was filed in U.S. court. Here's when the complaint was filed in Dutch court. Here's when the American
Dutch court got a different procedure.
Different
It
procedure.
separates the preliminary injunction from the
Correct.
merits. So that's your problem. You got two different procedures. So if you file this there in Dutch, yeah, it doesn't start till the merits start. The United States is pretty clear. It starts when you file the complaint that has substantive allegations in it. Dutch court knew that. So you now saying what's there to be, even if we, I don't get it. I mean,
The Dutch court
knew
had-
this, just what you just said.
Yeah, the Dutch court knew it all along, and the Dutch court originally ruled in our favor. In fact, in its decision, it said
It ruled in your favor
Demarcians.
because the Dutch council stood up and said something about May 22, 2022, a date that who knows where it came from. And he says that has to do with discovery. May 2022 had nothing to do with anything. True?
Your Honor, there was, and I forget exactly what it was that started on May 22, but it was a discovery.
It was what the Dutch council represented to
Correct.
the Dutch court that the merits of that case started May 2022. Is that not correct?
It is.
So why does that sound like it's foreign to you? I mean, that was what I thought. I'm just trying to understand where you're coming from.
I may not be understanding your question, Your Honor. The fact is that the Dutch
The
court.
question really goes, and I'll just leave it here. The Dutch court knew everything you are telling us today. You are saying there's something wrong with the American court statement. It's not wrong in saying when the action on the merits started here, because it started when the complaint was filed. That's not wrong. The Dutch court knew that. It also knows what Article 12 is, and that is that they have a different procedure. And it could have said just what you said. No, we're not going to pay that any attention. We're going to follow Dutch law. It did not. It followed the American law. You now want the Dutch court to come back and say, follow your own law. So you're saying the Dutch court erred by not following its own law.
It only did that because of the district court's order, which we believe is error. But even taking that aside, even if there is no irreparable harm, there's pendent appellate jurisdiction because the issues with the extraterritoriality of the Second Amendment preliminary injunction and Mr. Millen's affidavit, which also talked about extraterritoriality, are interwoven with each other. But to proceed,
That's a totally different, Mr.
it is a
Miller.
different basis for
Well, different
jurisdiction.
For this reason, the district court treated it different. It gave it different type of sanction, treated it totally different from this. Different. That's not your case. That's Millen's case. We're going to hear that next. That's not your case.
He did hold Millen and Demark Advisor both in contempt.
But separately, different type of sanction. You got money
Different
sanctions. He got a different type of sanction. Basis is totally different. Two different cases. Then there's no intertwining that I see.
It's because Mr. Millen's affidavit was all about, or was substantially about, the second half of it was about extraterritoriality principles of U.S. law. And segueing into the Second Amendment preliminary injunction, a big part of our argument is that that injunction, paragraphs 4 and 5, are still extraterritorial. What they do is they forbid uses, infringing uses in commerce entirely overseas. This would forbid a Polish website in the Polish language on a Polish server in Warsaw from using the trademark, and that's purely extraterritorial, even if a United States IP address could stumble across it. But that's not the only problem with the Second Amendment preliminary injunction. This copyright issue, paragraph 3 of the decretals, used to be based on copyright law, and the district court just switched out trade secret law for copyright law, even though they're different. They have different elements. They provide different protections. It didn't even say which part of the source code is trade secret. It didn't even specify if it was the 2012 source code or the 2021 source code. That bleeds into the Rule 65 problems. In Thomas versus Brock in 1987, this court said when you have an order that includes the decretals and then a separate document that includes the findings of fact and conclusions of law, that violates Rule 65 because all the decretals are based on the findings of fact and conclusions of law. But it has to be one order. There's not allowed to be any cross-referencing. One of the primary sources the other side cites is Thomas and Wright. But what they say is very telling. Possibly the crux of the portion of Rule 65 is the prohibition against incorporation by reference. So those are some major problems with the preliminary injunction. You know, one more piece of the extraterritoriality problem is the tortious interference claim that the district court has willy-nilly applied to tortious interference that could happen completely in Vietnam or solely within Beijing. It's just applying this law extraterritorially, and that is substantial error. And there's no question that the court has jurisdiction over the second amended preliminary injunction.
What was the effect of the prior panel that ruled on that order of this court? In this court, I mean, initially there was an order that was appealed to this court.
That's right. And a prior panel ruled.
So the kind of arguments you're making now weren't available to argue to that panel.
Correct, because Abitron is intervening authority.
Abitron affects trademark,
Yes, Abitron was a Lanham Act decision.
and so this correction order address that part of it that would say, okay, we're not going to apply that to international situation, only to the United States. That's what the district court did to correct it.
The corrections order didn't address tortious interference. What it said, the
It shouldn't,
corrections order.
because who said Abitron applies to tortious interference?
No one, the affidavits and the pleading notes don't mention Abitron because it hadn't been
Who says it
decided.
applies to tortious interference?
The New York state courts follow the federal presumption against extraterritoriality. So any decision from the federal Supreme Court clarifying that presumption necessarily affects the state law analysis. We've cited to the cases in our brief where the North Carolina courts look to the federal presumption. So we don't think the law of the case doctrine would apply here.
So you don't think Abitron just applies to trademark, it applies to tortious interference? And what about that other one? Is it a Trade Secrets Act or something? You think it applies to that too, huh?
No, Your Honor, the Defend Trade Secrets Act does
No,
apply
Your Honor, what?
extraterritoriality.
I want to understand. I'm not trying to be argument. I just want to understand your answer
Yes.
so we don't be misunderstood. What do you mean no? No, it does not apply, or no, it does apply? What does it apply to, Abitron?
Abitron is a decision, number one, about the Lanham Act, and number two,
Yes.
about the presumption of extraterritoriality.
With regard to trademark law.
With regard to trademark
Right,
law
and-
specifically.
And you want it to extend to everything essentially that's substantively before us, isn't that correct?
Not the Trade Secrets Act, Your Honor. We concede that does apply extraterritorially, right?
But-
That meets the first Abitron step where it does apply extraterritorially.
Why wouldn't all of these different torts and everything hinge on the same principle, and that is that you have undertaken commercial activity within the United States. Any kind of long arm statute would read to that. But the main thing, I think, in addition to the websites and the special access that's accorded, is that you enticed at least one U.S. customer, I think the name is Clarison, to switch from D-Ink to DBV. And given the fact that you have clearly engaged in at least some commercial activity within the United States, it doesn't seem quite right that you would be able to engage in that kind of activity within the United States and then say that all of these different, that Abitron should be extended, and that all of these torts that may have been committed abroad, you can't reach them. And the concern I have is that the broadening sweep of Abitron that you're advocating will leave American companies quite unprotected in the situation that foreign companies can come in here and engage in all kinds of commercial activity, and you've clearly engaged in some kind of commercial activity, but then you're saying that in trademark infringement and others are not reachable in terms of its in terms of the DBV's activities abroad, and I'm worried about that. To say that American intellectual property law never applies abroad would be severely damaging the ability of American companies to protect their interests. That just seems to me very one-sided to say you can come in here and do all kinds of commercial activities here, and then, but that it's off bounds when we were looking at what you've been doing abroad.
Your Honor, I see my time has expired.
Yeah, I'm just concerned basically about the extension of arbitrage that you are advocating leaves American companies completely unprotected from trademark infringement and intellectual property theft and a whole lot of other things, even when you have engaged in what seems to me to be some rather tangible commercial activity within this country. Why am I wrong about that, about being concerned about American companies abroad or about foreign companies being able to dive into the United States, lure customers away from DINK, and then say, well, go back abroad and say, well, here's the principle against extraterritoriality, and we get to do whatever we want to do, and you can't do anything about it, and that seems to me really to just encourage all kinds of intellectual property theft, and to produce a pretty one-sided arrangement, because when you engage in commercial activity within this country, you do so with your eyes open that the activities that you're engaging in abroad, you might have to answer for them in an American court. That's what I'm concerned about as a bottom line, is that you're just stripping any kind of protection from American companies abroad, even when the foreign company has come in and engaged in commercial activity of its choosing within the United States.
Your Honor, if I may very, very briefly respond. Abitron is controlling case law, and it says infringing use in commerce that takes place entirely in a foreign country is not covered by U.S. trademark law. So just because a random person from Wyoming might happen to stumble across a Polish website with an American trademark on it doesn't mean that an American court can prohibit purely extraterritorial conduct.
When, for example, you induced Clarazin to switch from DINK to DBV, isn't that plainly commercial activity within the United States, at least in the contemplation of Arbitron? Isn't that exactly the situation that Arbitron is anticipating? Because when you're taking one company's customers and luring them to your home, to yourself, that may be lawful or it may be unlawful. I guess it depends on the means that you utilize. But the bottom line of your position seems to leave American companies in a highly vulnerable position. That's my concern. And I'd like you to allay my concern if you can.
Number one, all the foreign intellectual property of the foreign countries would come into play to potentially protect them. But number two, the Supreme Court has said foreign infringing use is not recoverable. Now, if Demark put up an English language website and said, or Demark Advisor put up an English language website that said, we really want American customers, maybe, and here's our Demarcian trademark, and we're trying to pass ourselves off as them, the district court could forbid that. But what they can't do is forbid foreign conduct that's not directed into the United States. And the things that you're talking about that the prior panel found occurred with respect to Clarisin, nothing remotely like that has happened in the time since, as Demark Advisor has been complying with the injunction.
Are we the first court that this issue has come into, or is there any other court that has held, just as you have said, the extension of Arbitron to apply beyond just trade?
Absolutely, Your Honor. We cited a whole bunch of these in our brief. Maybe the best one is Legal Force, RAPC Worldwide versus Legal Force Inc., where the Ninth Circuit said a Japanese company using the same marks for a Japanese legal services company in Japan, even though it might be accessed by U.S.-based people, is foreign conduct. Under Arbitron, the district court can't award damages for it and can't forbid it with an injunction. And there's a number of other authorities we cited in the brief. Thank you, Your Honors.
These other, excuse me, counsel, these other torts that you're talking about, which are trade secret appropriations and tortious interference with contract and tortious interference with prospective economic advantage, that form the basis of paragraphs 1, 2, 6, and 7. Why wouldn't they be under the same principle as the Lanham Act? Because the allegations were that DBV's harmful conduct included actions taken inside North Carolina. And I'm wondering whether Arbitron, it certainly applies, the principle of Arbitron certainly applies to the Lanham Act, because that was what was before the court at that point. But I'm not sure why a different principle with respect to extraterritoriality would apply with, let's say, tortious interference with contract. If that activity took place in North Carolina, and that activity, that allegedly tortious activity took place within North Carolina, I'm not sure why that wouldn't allow North Carolina courts to take into account the activity that a company was engaged in abroad. Why doesn't Arbitron, why doesn't the same principle apply that govern the Lanham Act, extraterritoriality inquiry?
Mm-hmm.
Why doesn't that same principle extend to, let's just say, tortious interference with contract?
So yes, Your Honor, absolutely. The North Carolina Court of Appeals in 2008, Sawyer versus Market, and in other cases said North Carolina's extraterritoriality jurisprudence follows the federal jurisprudence. So the same Arbitron framework could be applied to the North Carolina statutes. I would encourage the court to carefully scrutinize the authorities we've cited on tortious interference, choice of law, and extraterritoriality in our brief. For instance, we cite a case where there was a contract between someone in India and North Carolina. Someone in India convinced the Indian contracting party to breach the contract in India. And even though payment to a North Carolina in a North Carolina company in North Carolina was never made as a result, the North Carolina court said that's purely extraterritorial. So we do believe that the federal and state extraterritoriality jurisprudence is the same, and it all requires that conduct that's the focus of the statute or the common law tort to have actually been committed in the United States. And even if this court has held that that may have happened in the past, it doesn't justify the plain language of the injunction, which by its plain language undisputably prohibits tortious interference in Vietnam. And we're not running around doing wrong things. Demark Advisor is complying with the injunction.
Well, can you really say that you don't understand what the injunction means or what it prohibits when you have an extensive path of litigation here and you're well aware of what exactly what exactly was alleged? I mean, it seems to me in determining clarity in an injunction that it's possible to look at the history of the litigation, which may help inform the understanding of the injunction.
That's exactly what Rule 65 prohibits. An injunction has to be clear on its face. It has to include everything you need to understand it in the injunction itself. And Rule 65 says...
Well, we have some cases that indicate that this would be interpreted contextually?
Your Honor, I don't think so. I think what Thomas versus Brock says and what the plain language of Rule 65 says is that the decretals can't rely on cross-references to other documents. You have to be able to read it all in one place and clearly understand. And that's because, as the Supreme Court said, the contempt power is a tremendous power, and it has to be used carefully and only when there is a clear and unambiguous command.
Well, that may be the second case.
They'll certainly address it in more detail.
Thank you, sir.
Thank you.
May it please the court, my name is Pamela Duffy, and I'm here on behalf of the plaintiff Demartian to ask that this court uphold the lower court's orders. And I'm going to focus most of my comments and start with the preliminary injunction and the modifications that were made, because that is really the only order that is properly before this court jurisdictionally. I certainly will address the other orders as well and ask that they be upheld.
Mr. Hughes says the correction order is before us because that's an injunction.
Yes, so I'll address that question. It is not an injunction because when an injunction is issued that is immediately appealable, that is one that goes to the merits of the claims before the court, the claims that are addressed in the complaint. The correction order has nothing to do with the claims. It has to do with the court taking steps to protect the integrity of the proceedings, the counsel and parties that are before the court, and to ensure that
Can I ask you, because I want to follow up on what I asked previous counsel. To what extent does the underlying principle of Albitron apply not only to the Lanham Act, but to the common law torts that are alleged for tortious interference and the like? We operating, or should we be operating here under purely a Lanham Act approach, or should we be operating here under a general principle that if a company engages in commercial activity within the United States and within the borders of North Carolina, that its actions abroad will be open to scrutiny? And a lot of what's alleged here not just would be the locus of the tortious activity here was alleged to be in North Carolina. And if that's so, wouldn't that bring the North Carolina tortious activity within the arbitron principle, so that we're working under a general principle that if you engage in allegedly tortious activity or unlawful activity within the United States, and as far as common law torts are concerned, within the boundaries of North Carolina, that your actions abroad are going to be subject to scrutiny by American courts. And is that a workable general principle to follow?
Yes, I agree with that, Your Honor. The Arbitron case dealt with the Lanham Act. And I think what happened here is that, well, of course, this court 4 years ago upheld a narrow injunction. Arbitron came down, and one of the things this court admonished or noted was that as things change in the case, the district court, of course, should revisit things. The district court appropriately revisited Arbitron and the injunction in light of that case as it relates to the Lanham Act. There's nothing in Arbitron that addresses the state court claims, and in fact, under the Woody case, 143 F. 4th at 259.
Arbitron doesn't address common law torts.
At all.
One way or another. The common law torts were not a part of the opinion. And so,
correct.
I'm just saying, but wouldn't it be true to Arbitron to take a sort of a long-arm view of tortious activity that was in North Carolina, and if you've got minimum contacts within North Carolina and a sufficient connection with North Carolina, then that would open you up to scrutiny of what you've been doing abroad. And your view is that that's very much within the contemplation of Arbitron, and that there's no reason for variation from that.
There's no reason to go back and revisit the state law claims as opposed to what was upheld in the prior injunction order. Again, I think what the defendant is trying to use Arbitron to stretch it to the state court claims in a way that is not consistent with the law of the case and this court's findings previously that the North Carolina claims could reach the actions of the defendant abroad, including all of the provisions really other than paragraphs 4 and 5, which dealt with trademark issues, and paragraph 3, which dealt with the copyright issue, which is a separate event that the court revisited. Everything else is unaffected by Arbitron. Everything else is simply the law of the case, because Arbitron didn't require the district court to go back and re-examine all those other provisions that were based, at least in part, based on state law. And in fact,
you heard Mr. Hughes refer to, well, there are other cases that have addressed this and come out differently than the way in which is being posited by Judge Wilkerson and your position here. Are you familiar with those cases?
I'd be happy to address those cases, Your Honor. I believe they're on pages 33 to 36 of the DMA's, of the defendant's main brief. And those cases, there's a whole string side of them. None of them address the case that's before this court. I guess the closest one, as Mr. Hughes indicated, is the Legal Force case. But even there, what happened in that case was the court examined the defendant's U.S. conduct, which had related to the sale of some equity shares in the company. And the equity shares in the company, equity is not something that's covered by the Lanham Act. So the court addressed that and said, well, that can't be addressed under the Lanham Act. There was also software, which is a product like here that could come under the Lanham Act, but there was no evidence in Legal Force, unlike in the instant case, that it was ever offered in the United States. So that case is distinguishable on its facts. It simply doesn't present the situation here where we do have U.S. directed conduct. Clarazin, as Judge Wilkinson mentioned, and additionally, there were, at the outset of this, when the website was cloned, in the defendant's efforts to continue the business free of Demartian and using its entire store of IP to compete with Demartian, as this court noted, that website included a particular link for customers, quote, in the Americas. So unlike Legal Force, there is a variety of U.S. directed conduct that does support the claim. And again, the district court...
Well, you would certainly have, at a minimum, the kind of minimum contacts that were necessary to establish personal jurisdiction. And it may not be that the commercial, that the formulation that Arbitron used is entirely duplicative or consistent with personal jurisdiction, but the contacts needed to establish personal jurisdiction under a long-arm statute, that's got to have, if those are satisfied, that's got to have some bearing and applicability, I think, on the Arbitron principle.
I would agree, Your Honor, and I think that there's ample, that the district court was correct in finding that there was U.S. directed conduct consistent with Arbitron, and then crafting, again, an even narrower injunction that said, you know, you cannot have a website that uses Demartian's entire store of IP, and that's not exactly how the injunction is worded, but cannot have a website that is accessible in the U.S. And that's very simply accomplished with a geo-blocking. And in fact, that's what's been done for several years while this case has been pending. There's a geo-block to prevent U.S. customers from reaching those sites. That is not a huge burden on the defendant. And again, I think the court was very careful in crafting this narrow result. It had to address Arbitron. It addressed that.
Okay,
and
Ms. Duffy, could I ask you about
Yes.
the language in the second amended preliminary injunction?
Yes.
And the term trade secret source code?
Yes.
What does that mean? Is it the same as the copyright source code, or is it something different? And how do you address opposing counsel's argument that it's impermissibly vague?
It is not impermissibly vague. The whole case has been litigated on the premise that the code that my client provided to the defendant in the course of the parties' contract of cooperation, that is the code. That is the code that's been, that was used, and I think,
Right,
Your
well,
Honor.
how is that, I mean, is this a term of art, trade secret source code, that the parties have consistently referred to? It does appear on its face to be unclear. So if you could help us. Start by saying, is it the same as the copyright source code?
Yes.
Okay.
It is the same code that was used during the parties' contract of cooperation. It is the same code that that was at issue in all the claims, and that has been litigated extensively up through the time that they ceased doing business.
If I interpret you correctly, is that the litigation history here bears upon the question of whether someone can understand the meaning of the injunction?
Yes, I think that contextually there's no question here that this is what the parties have been litigating.
As a result of the litigation history here, that they knew doggone well what the preliminary injunction prohibited. I understand that, but you know, on the other hand, there's a value in the principle that the preliminary injunction should be textually clear on its face. And when we go beyond that and start talking about the litigation history and what would somebody would they reasonably understand it? Probably here in terms of the litigation history, they would understand what those terms in the preliminary injunction meant. But I don't know, I'm kind of on the fence about that.
I understand, Your Honor. Again, the case has been about what IP of demolition was used during the contract of cooperation.
Mm-hmm.
The injunction was entered.
The broader question and the core of this, much of the core of this case is that I can't believe that Albitron says you can come into this, a foreign firm can come into this country, take full advantage of its commercial opportunities, allegedly commit torts, allegedly commit intellectual property violations, statutory violations, and then when we look abroad, we're abroad, principle of extraterritoriality, can't do a darn thing about it. And I just can't believe that where there's this kind of commercial activity involved, that the actions abroad, as unlawful as they may be, are simply beyond the scrutiny of an American court.
Well, I agree, Your Honor, and I think it goes back to this court's comments in the original injunction that there's a balance to be held between comity principles of respecting, foreign courts and their purview over things that happen abroad, and protecting American companies who go abroad, because if you create too big a deterrence that to do business abroad puts your entire shelf of IP at risk, then it's going to deter American companies from doing that business abroad. And I think that that's exactly what's at issue here, that those comments that the court made previously bear the same today. So in short, we would ask relative to the preliminary injunction that the court uphold the very carefully crafted narrower preliminary injunction and not agree to throw the baby out with the bathwater, essentially, which is what the defendant is asking to do. Arbitron changed the landscape, but it changed it in a much narrower way than the defendant would have you believe. Again, it's not a basis to throw out the entire injunction. And the copyright claim, again, we understand that had also had a change on the landscape, but that, again, was addressed in paragraph 3 with the changes to cover the trade secret code that everybody knows has been litigated.
I think that American companies are facing a real problem of intellectual theft abroad. That the piracy of not only trade secrets but all sorts of cutting-edge technologies and the rest, you really, American companies really have a problem with intellectual property theft. And it seemed to me those folks may have been asking for a degree of immunity for conduct that was piratical and piracy. And even when they've taken advantage of all the opportunities that our commercial marketplace allows them. That's what doesn't add up with me.
I understand, Your Honor, and we would agree with the court's concerns and comments. I will say just for sake of clarity. Again, the injunction issued based on the trade secrets that were the subject of the party's continuing contract of cooperation that terminated in 2021. Plaintiff, for sake of clarity, does not contend that this injunction attaches to any other code that the defendant is maybe using. That is not what's addressed in the injunction. That may be a subject for damages, but that's a different issue. The trade secret code, again, is the trade secret code that was
Judge
part.
Wynn made some, I think, very insightful comments about the whether we possess jurisdiction to review the correction order.
Yes.
And I'm not sure that we do, because the Dutch court has stayed the action here. That makes it difficult to prove irreparable harm. And it seems to me that whatever we did with the correction order is not likely to have the effect that it would have on the Dutch court's decision-making process seems to me highly speculative. So I don't know how you get to irreparable harm under the Woody principles when it's just a matter of really gross speculation whether the corrections order has the slightest impact upon the Dutch court's decision-making process.
The only issue with the correction order or the only action that the correction order took was to make sure that the Dutch court had accurate information about what was happening in U.S. proceedings. In a parallel proceeding, that's a legitimate concern of the court to make sure that accurate information is being conveyed in both directions. Dutch court made its decision to reconsider the stay.
I think Judge Wynn made a telling point when he says, do you think that the Dutch court is moving around here in the dark, that they weren't aware of the total landscape? And that seems to me to make sense.
I think that once it became clear that it was on the merits, and I see my time is up, may I finish my answer?
Yeah, sure.
That once it became clear that the May 22nd, 2022 date came from nowhere. When you look at JA 15, that's the docket. There's nowhere on that docket that has anything to do with May 2022 or May 22nd, 2022. So I think that once that point was clarified and the court understood that under our law, the case commenced on the merits with the inception of the complaint, which I believe is the same time that, or the same act that commenced the case on the merits in the Dutch case in October. So it simply corrected that information, and then the Dutch court did make a decision that, was based on correct information, and that there's nothing in that order from the district court that in any way told the Dutch court what to do.
Okay, well, we thank you.
Thank you, Your Honor. I appreciate the time.
And Mr. Hughes.
Thank you. The copyright claims are out, and the district court's injunction has to be justified, if at all, on other bases. I do want to talk briefly about the sanction. The sanction was a guess, a pure guess. This court, in the prior panel opinion, said you have to base your compensatory sanctions on competent evidence. And the district court ignored that and said, I think it was 150 grand, and took a guess from an audience member, translated that in from euros into dollars without even doing an exchange rate. So the sanction has to be vacated at the
You're talking
minimum.
about the contempt order,
Correct, the contempt and sanctions.
which is interlocutory.
We believe that it's inextricably intertwined, that there's pendant jurisdiction. But, even if all you have jurisdiction over is the injunction, I just want to make absolutely clear, Demarcian has conceded that the injunction is extraterritorial. In their brief in the Millen case that you'll hear argument about in a moment, they say, quote, on page 17, quote, "Indeed, the injunction still retains extraterritorial reach." They agree that it reaches extraterritorially. And importantly, Judge Wilkinson, to some of your points, this injunction right here today is not about what this court found about Clareson back in the day. It's about what Demark Advisor is allowed to do tomorrow. And if you read the second amended preliminary injunction, especially paragraphs 1 and 2, Demark Advisor can't sell a mop bucket in Argentina. That's just way too broad. And it is unjustifiably extraterritorial. I do want to make sure that I emphasize that there's a distinction between personal jurisdiction under the long-arm statute and which law gets applied by the tribunal with personal jurisdiction. This court's decision in Barnes from years ago is a good example. There was a case in South Carolina where a South Carolina federal court applied tortious interference law from Ohio, South Carolina, Florida, Louisiana, which didn't have a claim for tortious interference, and so the claims against the folks who were acting in Louisiana were completely dropped in that opinion. We think the same analysis holds true here.
I guess this may be a matter for the second case, but just because we don't have, even if we don't have jurisdiction over the corrections order, we still may well have jurisdiction over the appeal of the contempt order.
Absolutely.
Just because of the, you have a non-party exception to the final judgment rule. And so it doesn't seem to me that you lose getting at the contempt order, at least as far as the attorney is concerned, under the non-party exception. That we could still look at that.
Absolutely. And then the corrections and the contempt as against us is pendant with that.
I don't
Thank
get
you.
it. I don't understand that. I understand it applies to the next case, non-attorney. You don't have that in this case. This case is different. This case is different from, those are two different cases. I don't understand what they absolutely means in reference to that question, which I think is a great question. I think it hits to the point of it. But that's the second case, not this case.
Yeah.
That's true, Your Honor.
So
But
what is the
if
absolute
you have
that
jurisdiction,
favors you? I mean, you said it as though it was something that was in your favor. I don't think it removes it from being interlocutory, given the posture of what this case presents, as opposed to the second case. So the
absolutely.
jurisdictional issue from that perspective is controlled, you know, I mean, when you go back to the Best-Wall case.
Correct.
At least for-
But
in
if this
terms of
court
contempt.
has jurisdiction over the next case because of that
We'll deal
contempt
with the
order,
next case, yeah, but it's a separate case. That's not your case.
I think the principles of pendant appellate jurisdiction would still apply, and all the contempt issues against Mr. Millen are all wound up in the corrections order and the contempt issues against us. Thank you very much.
All right, we thank you, and we'll come down and greet counsel, and let's see. And we'll be glad to hear the second case. Mr. Hartzell.
Thank you, Your Honor, and good morning. May it please the court. Sam Hartzell for Appellant Press Millen. The district court held Mr. Millen in civil contempt and suspended him from admission to the Western District of North Carolina because of a decision only a Dutch lawyer can make, what Demark Advisor files in Dutch court. The court should reverse that contempt order for 3 reasons. First, there is no evidence that Mr. Millen violated the correction order. To the contrary, the record shows that Mr. Millen and I took the steps within our power to achieve compliance with that correction order. We took those steps together. The record shows no daylight between us. As U.S. counsel, we jointly instructed our client to file the required statement. But we hit a wall. Mr. Mayboom, the client's Dutch counsel, has the absolute right under Dutch law to control what Demark Advisor files in Dutch court.
The district court seemed to be concerned Mr. Millen didn't do what you did, that is to actually deal directly with the counsel there. But I'm assuming that of these 3 things you're going, it seems to me the harm one probably is the one I would focus on, but I'm just thinking, you know, in terms of, well, he did it, but this is civil contempt. It's very difficult to look at this case, and there are violations. It seemed to me very clear, and I think this applies to him, to be quite frankly. But I'm not so sure from a civil contempt perspective that exists here, because this is not a criminal intent. I mean, the punitive things of not following my orders, or not doing it, whatever, there is, at the end of the day, is so what? Because ultimately the court did it. You tried to persuade the counsel to do it. He wouldn't do it. There's no indication he would do it otherwise on it. So that seems to be the focus to me of the case, if from your perspective.
You're right, Your Honor, and you know, as my colleague Ms. Duffy just said, the important point is the Dutch court had accurate information. The Dutch court had all this information in front of it. But what harm is an element of civil contempt, and that is an important requirement because of the potent, awesome power of civil contempt. But I want to make clear that Mr. Millen is not standing up here right now through me saying, I violated the order, but no harm, no foul. Yes, that is an important part of our argument, but the lead argument is we complied with that order. You know, I could imagine a lawyer.
But you and he are not the same person, and I think that's where the district court went with this. District court gave a specific rendition of what it wanted done, and that seemed to have been the focus the district court was taking on this, is you didn't do this. But it also gave it it's almost like wondering why you just didn't issue a conditional situation. If you don't do this, then I will enter contempt, and allows him to purge himself of it by doing. Has he done that?
No, Your Honor. And
can he do it?
Could the district court?
No. Can Mr. Millen purge himself of this contempt by simply complying with the order in the manner that the district court wants him to?
No, as a matter of practical impediment and as a matter of conscience. Practical impediment.
I got all that conscious and practical stuff. I'm talking about a contempt order, about a federal district court order. It's practical policy. I'm talking about getting rid of an order. Can he? What is it that the court? What specific the court wants him to do?
He has to file a statement in Dutch court.
Yes. On
behalf of Demark Advisor, apologizing for his own statements, which he believes are true.
Well, maybe on behalf of his client, but it was really a statement he made. It was his affidavit. Apologize for what the court perceived to be misleading statements. He didn't say it was wrong, whatever. And rightly, there may be something to support the position he was going if you look at it in the manner that the counsel previously put it in. That is, under Dutch law, that would have been true, and may have been that. What's missing is from that, which I think is a fair statement, except for this point, you didn't tell what was going on, what the American side was it. That's not true in America. It may be true here. And so my question is it just a matter of pride or you don't want to? I mean, it seems to me if you just send a statement and says, well, I may have been misleading the court. I'm not going to say this is going to be sufficient for the district court, but I'm just saying, but I did this. It appears as though the court in America interpreted that to be misleading, and to the extent that it was interpreted in that manner, I sincerely apologize to this court. It's just a courtesy. And then once you do that, take it back to court, says court, judge, apologize, and boom, gone. That sounds simple to me. But you could press it on and says, well, I'm just right. And, there is another component of this that I wouldn't want to see come up. I mean, to the extent the district court has gone in this direction, may not be a contempt order, but it certainly seems to be, from the district court's perspective, an ethical consideration. I mean, that would be, if a federal court has interpreted you misleading, that's pretty powerful stuff on an ethical type situation. I don't know if you need to go there. I'm just saying, because if you could get rid of it, why wouldn't you?
I understand the concern.
Not a concern. It's really a question of, just tell me why you wouldn't, what prevents that, other than, as you say, the practical or the moral side of it. It seems like my pride would be hurt.
Yeah.
Which I think you could do it in a way sometimes you do have to get up and apologize. And it doesn't have to be like, I was just wrong all of it. I did it for a reason. The court didn't accept my reason, which happens all the time. And I apologize to the extent that it appears as though I may have been misleading the court. I never intended to do that sort of thing.
Yes, Your Honor.
That sounds so simple.
I do want to make sure the court is considering the DeWolf Declaration that explains why, as a matter of Dutch procedure, it is not a simple thing. In fact, it's impossible for somebody other than Dutch counsel to make a decision about what gets filed in Dutch court. Mr. Mayboom appeared in district court and explained to the district court that the compliance was to the maximum extent, in his view, that could be done. I don't have a view as a matter of Dutch law whether he's right.
But it's just a statement, and even that could be put in the statement. The statement could be simply saying, as I understand under Dutch law, the American court is interpreted a little different, but that's my position. You see where I'm going with this?
I do.
It's a very nuanced statement that could be just submitted. You take it back to that district court, I think probably district court would say no contempt. I mean, it's gone. I think.
And that's part of what we tried to do in my declaration, looking at page JA 1707, is the email that we sent. Mr. Millen is on that email to Dutch counsel saying there's concerns that are being raised here about whether, we have fully conveyed, the district court's perspective on this. Let me allay those concerns. Here is a draft statement from me as U.S. counsel.
Let me ask one last question. I'll leave that one. I want to ask this. Are you saying he cannot file a statement himself in district court? It would have to be done to the lawyer, from the Dutch lawyer?
Yes.
You're saying you, as a lawyer here, cannot do that. They don't allow pro VC or whatever type, you to practice it, and you just can't put something in the record there. But
yes, Your Honor.
You could submit it to the counsel and ask the counsel to do it, and then come back and says, Your Honor, I've done everything I possibly can do to get it before the court. The counsel, if the counsel doesn't comply, it's not on Millen, it's on the counsel.
And that's what we did, Your Honor. At JA 1708, Mr. Mayboom responds, thank you for the draft statement. We cannot use it. We are not allowed to make filings. I will not submit it.
And you took that back to the court and says, Your Honor, we have now sought to comply with what you said I should do by providing this to counsel, and I cannot myself directly give it to the counsel, to the court. The counsel won't give it, but I've done what I can do. You told the court that?
Yes, and it was on file with the district court before the contempt sanction issued. And we filed it after the show cause hearing because these are privileged communications. If it was at all possible.
As I understand it, you're making two arguments. You're making the initial argument that the Dutch Dutch court was the proper court to issue a contempt citation, number one. And then number two, I thought you were making the argument that even if that's not correct, and the American court had the ability to issue a contempt sanction, that your client's arguments were still a good faith interpretation of the court's order. So I understand you're making two arguments, aren't you?
We're making a series of them, and they build with the original affidavit. Our argument is those legal positions were correct. Every day before your honors, you hear opposing counsel make arguments. One of them typically loses. That doesn't mean that that lawyer has made a misrepresentation. It means that your honors accepted one position over the other. We think Mr. Millen was right, but even if that's not true, even if you disagree that he had the worst argument there, we think it was well supported. That's step one. Then step two is the district court says, I disagree with your position here, Mr. Millen. I want it corrected. But the district court did not enter an order saying, Mr. Millen, go correct it. If that was the order, it would be a very different situation. It would be clear that the obligation was incumbent on Mr. Millen specifically. Instead, what we have is an order that says counsel for Demark Advisor. All agree that could have been if Mr. Mayboom had filed that statement. Nothing is required of Mr. Millen. If I had gotten that statement filed somehow, nothing is required from Mr. Millen. So it is not an individual obligation that is placed upon him. It is an obligation for Demark Advisor to comply with the order, whatever that means. Third step in the chain is, okay, even if Demark Advisor violated that order, which we're not conceding, but for the sake of discussion, let's say the correction order
I'm looking at this, that this may just be a very unfortunate case of misunderstanding, that there was a lack of communication, that the attorney Mr. Millen should have been more scrupulous and diligent in terms of interpreting the court's order. But it's not clear to me that this conduct justifies a contempt citation. That's my concern. Sometimes there are miscommunications, and sometimes there are, just misunderstandings. And the question is, does this fall into the miscommunication and misunderstanding and sort of good faith ability of lawyers to argue their client's case and the latitude we want to afford them in doing so? Or is this contemptuous behavior? Now, which bucket does this go in? Just putting the business aside about whether the Dutch court was the only one that had the authority to levy that kind of sanction. I want to know why you think this was just a case of miscommunication and misunderstanding, which doesn't really justify the kind of sanction that would ruin somebody's career or would impair somebody's career. And isn't that a part of it?
I appreciate Your Honor's sensitivity to the importance of this to Mr. Millen. Yes, if the order is going to be the basis for civil contempt, the Supreme Court is clear that it's got to be unambiguous so that person knows what is expected of them. The first time that the district court said, quote, Mr. Millen was ordered to correct is in the contempt order itself. I'm quoting from JA 1538.
I'm just not sure that it makes a difference, really, that this is civil contempt rather than criminal contempt, because even with a civil contempt citation, the reputational damage is severe.
That's right, Your Honor.
And you can say, oh, it was just civil contempt, but the fact that someone cited somebody the court cited him for civil contempt, that's a pretty damaging remark in terms of a professional's career.
It affects his ability to, every time he seeks pro hoc vice admission, he can't practice in the Western District currently, despite being admitted there for decades. But I do agree with, I think there's a difference, Your Honor, between what would, erring on the side of caution, a person do to avoid getting crossed.
Why isn't this a question of whether or not this citation was too harsh given the circumstances?
Because the elements of civil contempt weren't met, because there was no evidence of a personal violation of a clear order by Mr. Millen, and there was no showing of harm. But I really do want to make clear, I can imagine a lawyer, Your Honor, confronted with this correction order who says, I don't think my client should follow that. I'm going to tell my client, the order is what it is. I'll advise you of the consequences of violating it. You make your own decision about what to do. That is not what happened here. Mr. Millen and I were clear about our law firm's instruction to the client about his obligations.
Okay, but this is the point. We are debating what exactly happened here, okay? You have one view of what happened here. Opposing counsel will have another view of what happened here, and we're sitting here arguing about what happened and what did not happen here. Now, I get that, okay, that's fine. But at the end of the day, it seems to me the question is whether the contempt sanction was simply disproportionately severe, given the circumstances before us. And some of those circumstances are a little bit cloudy, but and the legal argument is interesting. I get that. I understand what you're saying. But the question is, this is a very draconian sanction for an attorney. And the question is, given the cloudiness and uncertainty about what actually did or what actually didn't happen here, I just wonder if it isn't too severe.
May I respond, Your Honor, or should I take that back up on rebuttal?
Yeah. Canada, you have some rebuttal time, maybe one of my colleagues.
Yeah, I think Judge Wilkerson's question is a good question, but I think you're trying to posit under the elements of contempt. I think it comes under harm because of the differentiation between what civil contempt is for, which is to benefit the complainant, as opposed to a criminal contempt, which is really dealing with the authority of the court. The judge here, I agree with Judge Wilkerson, that's a pretty harsh sanction. Doesn't seem to have any connectivity with the complainant, but on the other hand, goes back to my question to you, and that is, it was really intended to say something the court probably thought you would do is to go give it to the court. Now you say something was given to the lawyer, but what I saw was something that had your name on it, not his. And I think that's a problem for the court when you give something there. I think it can be cured, and I say that the personal side to it. I know you lawyers, you have an excellent reputation, and I don't understand what went on between that district court judge and these lawyers and this excellent lawyers here and this excellent law firm to bring this to our court. It seems to be an embarrassment to me, and I'm suggesting the court may have thrown you a bone to fix it with a little nuance, because even if you win here, you still got this on the record somewhere. But it sounds like to me, if you do try to do what the court did, simply take your name off of that little email, put his up there and send it and say it, then he's done it. And then it goes away. That just seems like to me to be the best way to solve this case, even if we agree with you. Because then you got all this over the record with that. But if you did that, sometimes before an opinion comes from this court here, there would never be an opinion from this court. Wouldn't be all over the record and all of that. You know, I know. I just put that to you. But I think Judge Wilkinson has a point there. And ultimately it would, but it's still going to deal. It fits on the elements to me on the harm, but that leaves the rest of it kind of in place. I mean, so, but I just throw that to you to think about a way in which, you know, I just believe you could do it.
Thank you, Your Honor.
All right.
Good morning, Your Honors. May it please the court. David, sorry.
Please, go ahead.
Good morning, Your Honors. May it please the court. David Dory from the law firm of Blank Rome in Wilmington, Delaware. Before I get into the argument and address, I'm going to go off script and address these points directly in a second. This is a position, it's the first time I've ever been in this position. I hope I'm never in it again, because I feel the sensitivity.
What benefit are you going to get out of it so that Mr. Millen wouldn't be able to practice in the West? I mean, civil contempt has it's different than criminal contempt. I mean, it's the benefit to complainant as opposed to a criminal thing. What's the benefit? I don't think you want him to not be able to practice. Something tells me, I don't think you're going to stand up and argue and say, we want to keep him from not practicing.
No, I'm with you. I understand that.
Yeah, so it's one of those cases. I mean, I think we out in the Fourth Circuit. We're very civil and collegial court up here. It just seems like lawyers. I think this could be worked out. Maybe I'm pushing too far, Judge Wilkinson, but it just seemed to be simple to me that what the court offered, right or wrong, could easily be done, and this would go away. But from your perspective, I don't see the harm. And that's kind of the element here. I know you say you had delay and all this other stuff that goes on, but I just don't see the harm in it, to be honest. But it leaves in place the rest of the elements, which is not favorable from Mr. Millen's place, reputational-wise. It's still kind of on the record. And I'm positive in a way in which I think it sounds like to me it disappears.
There's tremendous harm here, and it comes in the context of how we got here. So in appreciating the sensitivities of why we're here, and I hope we never have to do it again, nevertheless, my client was put through things they should have never been put through. And it started in December of 2022 when the court made a decision to stay the action denying my client's...
Differentiate when you say the court. Tell me what
the Dutch court.
Okay.
Fair point. In December of 2022, the Dutch court denied a motion by our Dutch colleagues who are here today to stay that action in favor of this as a first filed action.
Does the Dutch court permit American lawyers to come in and submit and make arguments before it, or must it come from the Dutch lawyer before it?
I don't know that for sure, but I can answer your question as to what more they could have done, and I can jump to that.
No. I want to hear that, because that was kind of interesting when I heard that there's only, that Mr. Miller can't go in himself and just file something because we told him to do it.
Right.
The court has to permit you to do it, and under Dutch law, the Dutch lawyer is the one to do it, and if he chooses not to do it, I don't know the avenue you would have. There may be some, you don't have to kind of common law rich we got, or some kind of way you could do it, but must this only be done through the Dutch lawyer, or can Mr. Hartzell or Mr. Millen individually walk into court, file it in Dutch court on their own behalf? Because actually, I think this is against Mr. Millen directly, that order.
Well, and
telling him to do it.
Excuse me, and that seems to be pretty much critical to the resolution of this
Sure.
case.
Absolutely.
Because if Mr. Millen can file something with the Dutch court, then it seems to me we don't have the problem created by the scenario where Dutch counsel is saying, I am not going to file it. So could you answer that question?
Directly. At JA 1361 is a declaration by Mr. Hobe, one of our Dutch colleagues, August 30th, 2024, and it was 6 days after Judge Ridinger held a hearing where Mr. Mayboom personally appeared and our Dutch colleagues personally appeared, and everybody had an opportunity to speak. Judge Ridinger was the epitome of judicial demeanor and restraint in the face of what Mr. Mayboom was arguing with him about. But Mr. Hoba, he then said, submit follow-up materials after this, and Mr. Hoba's declaration was submitted at paragraph 9, JA 1361. He notes that Mr. Millen could have filed a letter or sent an email on his own to the Dutch court.
To the court?
The Dutch court. And that
Who
is
says
a
he-
Dutch
who says he
lawyer
could
saying
do
that.
Who says he could do that?
Mr. Hoba is our colleagues in the Netherlands. We have two counsel here who are representing Demark in the Netherlands, and we have worked very closely together back and forth on these cases. And it goes to the heart of your concern about what's the harm here. Because once we found out in December of 2022 that it was denied, that the Dutch...
So he makes a statement and then sends it to the court, and the court can either accept it or not. You know, it actually, I guess if you read it in this real way, you send it to the court doesn't read it, that's the court. But the compliance would be to send a statement
Right.
to the court, whether it receives it or not. But I think he probably could do it through the Dutch counsel too, by simply doing what Mr. Hartzell did, same kind of, maybe email, whatever the statement is, just put his name on it. It seems to me the district court may well determine that is in compliance. And that's the part that I'm seeing missing here, that even if it doesn't work, pretty simple. I mean,
Yes.
just go back to the district court and says, send an email to him, put your name on it, and couch it, and then go back and says, okay, Judge, we've done it, we know this is for the Fourth Circuit, but we would ask that this be lifted and that
I
he'll be
totally
dismissed.
agree. And what you focused on is a really important point. It's what could he have done to try and minimize the
And
damage?
what would he need to say?
It would be a corrective statement, or it would make...
I understand the conclusion corrected statement. What does he need to say to amount to a corrected statement? Correcting what? Because you understand,
Yes.
what he said actually was okay under Dutch law. The question is, the misleading part, at least the court here determined, that, okay, that's not true under American law. But what he said for Dutch law was true. And so, if the court here determines it to be misleading, it wants him to go back and let them know, well, I should have also pointed out that in the American court, this is it. I was representing what I understand the Dutch law to be. If it was misleading, I apologize.
But that's
Seems
not
like to me, that satisfies, doesn't it?
But that's not what he was doing. The critical piece that Judge
Tell me
Ridinger...
what else he needs to say beyond that.
He needed to say what Judge Ridinger said, what he was supposed to say, and the simple reason is this. Judge
Well, at this
Ridinger...
point in time, there's no reason to go through that. I mean, you got to remedy it. The purpose for what he was said then is different. What he's now saying is simply, I'm complying with this contempt order. I mean, he's already got it. What good is that gonna do at this point? This is simply to satisfy the district court that he's not doing something intentionally or trying to offend the district court. He's complying with the district court's order to do that. He's not trying to go and convince them actually to do it anymore, because it's already done.
I understand, and the timing is the 6/27/2023 hearing. The court decides, the Dutch court reverses course in December of 2023 and puts a stay in place based upon the submission of the statement. So all those are true factors. But the fact was, and this goes to Mr. Hartzell's point, if you look at the order from Judge Ridinger, it said you're going to submit two statements, one by the company with a Dutch translation, and then it says one by counsel with a Dutch and an English translation, which can only be interpreted as meaning that something had to come from American counsel in some fashion. And in addition, the first paragraph of that says that statement has to say that statements made by Mr. Millen were misrepresentations. So it's clear that he's the focus of all that. But what I think the court needs to understand here is our client has this ruling in December of 2022. There's a trial set for July 5th, 2023. In March of 2020...
Well, you know, that when you really think about it, you put a lot on Mr. Miller in terms of what his little corrective statement, the court said it, really the Dutch counsel that went and represented that May 2022 date. The Dutch counsel stood before a Dutch court and said that. That was the basis for saying one was earlier than the other. American counsel comes in and says something. What does that mean? That probably means what it means here. If a Dutch guy comes in this court over here and you got two American counsels who say something, how do you think that's going to turn out? But, I mean, that was really the basis for it.
Well, what I can do is answer your question with the facts that are in the record. And we find out in 2022, there's a
But
trial.
it is a fact that the Dutch counsel represented May 2022.
He did.
It is a fact. That is incorrect.
He did. And here's where it gets very important for purposes of this hearing. We should have never gotten to June 27th, 2023, ever. On March 15th of 2023, starting at JA 720, we had a case management conference, and I went in there. I took a look at the pleading notes from the previous September provided by our colleagues. I looked at the decision the court made. I wanted a causal connection between the two about the misrepresentations. I was astounded. And I walked in, and Judge Ryder didn't want to hear it because it wasn't before him. I forced him to listen to what we were doing, and what I saw and what I found. Mr. Hartzell was in court. Mr. Millen was not. Then, on April 12th, we filed a motion to stay, an anti-suit injunction, and the very first paragraph of that says, we want an injunction to stay that case, them from proceeding with that case, because they made it falsely represented to the Dutch court. Now remember, our hair's on fire. This is crazy. We got a July 5th deadline coming
Falsely
up.
misrepresented what?
The proceedings on the merits in the instant case did not commence until May 22nd, 2022. That was in paragraph 1A of our motion.
Mr. Miller didn't make that misrepresentation.
It gets better. On paragraph 7 of the same motion, plaintiff at JA 773, plaintiff raised these concerns at the March 15th, 2023 status conference, which I just mentioned, and further met and conferred with defendant's counsel on April 5th, 2023, to determine if defendant was willing to take any action to correct the misrepresentations made to the Dutch court. Defendant was not willing to take any action. And then Mr. Millen shows up on June
Well, you
27th.
heard Judge Wilkerson talk about miscommunication, and some of that sounds like to me, because I'm thinking a Dutch lawyer is analyzing and looking at, because there's two procedures in Dutch law. Preliminary injunction is different from merits. The United States is different. Plaintiff comes in, it's all together. Dutch lawyer looks at it, says, oh no, the way this thing works is the merits is dead. All you got is a preliminary injunction. Well, that's not true in America, but he looks at it that way. He comes up with this May 22, the 2022 date, I guess, because that's when discovery or something. Maybe that's when he thinks it starts. So if American counsel looking at it says, well, that's what the Dutch counsel represented in front of the Dutch case, and it's really true. Under Dutch law, this is it. I don't see the problem. But it is a problem because that's not the American side.
Exactly. That's exactly right. And
But you see what it gets muddled and it gets really gray. What Judge Wilkerson posited, that sometimes it's just miscommunicating and how it, in other words, maybe enough wasn't said. You even said you had to force the judge to even get to this thing here. And
I appreciate
if ever I see the case come to us, they'll say, you guys ought to get together and work this thing out. It should not be up at the Fourth Circuit. There are some cases we ought to be dealing with, but you ought not. I don't see the benefit to you. I see no benefit that's going to you.
If you saw my clients run out of the courtroom on June 27th to catch a plane to the
But I don't see a
Netherlands,
benefit from
July
Judge,
5th.
from Mr. Millen not being able to practice in the Western District to you.
Oh, I understand the point, Your Honor. But that is
Other than I guess you wouldn't have him going against you. Huh?
No, and I'm sensitive to this. No matter how passionate I get, I'm sensitive, and I get that. And where I get frustrated is we never had to get there. We told them this. And when we went into court on June 27th, you can look at the transcript. Mr. Millen said, I don't know what misrepresentation I didn't make. He did say at JA 922, lines 15 to 18, I think if I were aware that Mr. Mayboom made a statement about the U.S. proceeding that was incorrect or about U.S. law that was incorrect, I would have a duty to correct that. Mr. Millen's own standards stated in court on June 27th. And so where I get frustrated and I watch my clients having to go fight that, and that decision in the Dutch court wasn't made until December 2023. And they're running into court on July 5th, and Mr. Mayboom is still arguing that it's wrong.
When did your relevant harm start?
Pardon me?
When did the harm that you claim start?
It started from the minute that they denied the stay.
You have a date?
Oh, I'm sorry, I'll stick right to it with Mr. Millen's comment. In my opinion, it started the minute I raised it in court on March 15th. Because we couldn't.
What year?
2023. We had a case management conference
And
where
then what was the date of the correction order?
June 27th, 2023.
So it started before the correction order.
Yes. No, the harm that ties to what he could have done.
Well, you just said it to me. You just said the harm started before
did.
the correction order.
Let
Yeah,
me-
you're
let me
saying the
back up.
correction order is to address the harm.
No, I understand your point. Let me back up a second. The harm to my
That
client.
was your point. No, I didn't say it.
No,
You said
I'm
it,
with you.
okay?
I'm with you. The misrepresentations that caused the erroneous decision in December. Keep in mind, the court, the DMA wanted Mr. Millen's affidavit to help them with that motion.
When did the harm start?
The harm to my client started, it started no later than June 27th, 2023. But, Your Honor, my issue with Mr. Millen is because we went through this straight from March to June to avoid June. And they would not, and Mr. Millen's own professed duty to correct it. He was told.
But he's in
And it's in the
contempt for the
motion.
June correction order, not for what's going on before June. So how's that harm before June being a contempt?
I
you
appreciate the point.
Can bring an order
I
later
appreciate
on.
the point. The harm for my clients started when they had to go into court on July 5th, 2023, to fight the Netherlands thing because of the misrepresentations. Remember, the reason the court issued the order and heard it so quickly was because trial was set on July 5th. So we heard it on the 27th. He told them to submit it by Monday, July 3rd. And the other side submitted. I'll go directly to your point, Your Honor. I understand exactly where you're coming from. Because Mr. Millen
Oh,
wasn't
you
required
corrected
to
it.
do
You
anything.
came back and gave me a date after that.
You-
That's what you just did.
Let me characterize it and be clear. My argument's twofold. One, if you apply a duty he told Judge Ridinger he had, we should have never gotten to June 27th. Now go. The order comes down June 27th. He's under obligation to file something by July 3rd. So I totally agree that until July 3rd comes and goes and it's not done, there's no non-compliance.
There's no harm.
No harm that stems from non-compliance. I do agree with that. And I apologize if I was confusing you on that. I do agree with that. And when I'm speaking of harm earlier, it's more on the broader DMA harm. I get that. And I'm concerned about what the implications to Mr. Millen as well. With respect to the miscommunication piece, I just told you why there's no miscommunication issue. Because this was all explained to him beforehand. And we all tried to avoid having to do this in the first place. Again, I'm not changing my argument. There was no harm. He wasn't required to do anything until July 3rd. But at the end of the day, when you look at this record, a miscommunication, there's no record evidence in this case that Mr. Millen did anything. I understand it could have been related to, I don't know, it could have been legal counsel, but I don't know. But at the end of the day, he didn't do anything, and that falls into two categories. One, he didn't try to send an email, he didn't try to send a letter, he did. We have Mr. Hartzell's comments about what they tried to do together. In my view, because Mr. Millen was the one asked to give an affidavit, and Mr. Millen's, the point of it was to explain to the Dutch court the implication of U.S. law, which directly impacted that decision. That puts him that puts him in the firing line for that. So once he doesn't make that, and this is the point, Your Honor, the statement from the U.S. counsel that goes to the Dutch court gives the Dutch court to say, Mr. Mayboom, stop on July 5th. Stop. We have a statement from U.S. counsel that says you misled us, because what I wanted as a Dutch court was U.S. law on this point, because I'm trying to compare which case started first. And that's clearly what the record reflects. They solicited that information. That goes to, Your Honor mentioned Article 12. It's directly in Article 12, firing line. So if he submits that statement, Mr. Mayboom is shut down. But he didn't. He kept arguing on July 5th. And if you look at when in the August hearing, before Judge Ridinger asked him, why didn't you just submit the order, Mr. Mayboom, and stop criticizing it? And he said, because the order doesn't say I can't disagree. And I think, Your Honor, I hold the right to find that, and I've all the right in the world to tell the Dutch judge that, just as I have the right to tell you in your face that I think you misunderstood me. That's JA 1335 on August 23rd, 2023. And that goes to the point, Your Honor, if there's a statement by American counsel because A, DMA offered one voluntarily, B, they clearly were making a decision based on U.S. law because to compare the merits, and C, if he submits it to say this was wrong, then the Dutch court has what it needs. And Judge Reininger was careful to avoid any
Before
interference.
you said, address Judge Wilkerson's concern.
Pardon me?
Share his concern, share, that a suspension of this type, reputation, is draconian. That, in other words, it doesn't seem to be any connection to anything with the suspension and a civil type action of this. Again, I'm still confused about the harm and the benefit. I mean, because that's really not what was actually the sanction. What was given actually didn't do any of that. It's one thing to give you $400,000 or something like that. I see a benefit there, but I don't see a benefit from the counsel other than you don't get that counsel to come against you, and I don't know if you claim that to be a benefit. But explain and I recognize I don't think they made a proportionality argument, but there is a question of the nature of this sanction, of this suspension, that it just seems out of proportion. It seems not to apply. What's the reason for it?
My time is up. May I address the answer to the question?
Sure.
Okay. One, in terms of harm, JA 1542, in the contempt opinion, was the court's determination of it, which was supported by JA 1341 and 1342, which was Mr. Jansen appearing in court on August 23rd, 2024 to address that issue. That was one of the things. So that covers at least the financial harm. Second, my client was still required to go and fight that issue to get it reserved. Let's go to proportionality, to get it reversed. Let's go to proportionality. I think what influenced the court's decision is this. Mr. Millen walked in, and you can read the transcript. He walked into court on the 27th and professed to not understand anything that was misstated. And I just told you the motion, that was just one piece of the motion. So we had conference, meet and confer, and motion. So I think, I appreciate it. So the bottom line is I think the court was influenced by a lack of action.
Counsel.
Thank you.
Thank you. Sorry.
Apologize, Your Honor. Thank you.
Jim, do you have? No. All right. Mr. Hartzell.
I think I understood my colleague, Mr. Dory, to say, quote, no harm that stems from non-compliance. That's the ball game on civil contempt. Harm is the fourth element of civil contempt. It must be shown by clear and convincing evidence. If there is clear and convincing evidence of a harm from violating a court order, if, as Mr. Dory, as I understood him to say, there is no harm stemming from that non-compliance, there's no civil contempt, there's no need to talk about the proportionality of the sanction. I do want to be clear that in all this discussion that Mr. Dory has been raising about alleged disadvantages they face in the Netherlands, all of that argument was about timing. Mr. Millen made no assertion, one way or the other, about when the U.S. case began, because he wasn't speaking on that question. He was responding to Ms. Duffy's affidavit, which herself said nothing about when the U.S. case began. So this is not a situation where silence by, rendered other aspects of his affidavit misleading. There just wasn't anything in there about when the case began. And yes, it is very important to Mr. Millen that this suspension be lifted, but it's not just the suspension, it is the civil contempt itself. That is the injury that we are seeking remedy for, the mere fact of being held in civil contempt. That's appealable in and of itself, the adjudication of civil contempt as to a non-party, and it has real-world impacts on him today. It's not just pride. What Mr. Millen has been ordered to do is to apologize to the Dutch court for arguments a Dutch lawyer made to the Dutch court. Think of the implications of that, what exposure that might have for Mr. Millen to say, Demark Advisor's Dutch lawyer, that argument that Demark Advisor's Dutch lawyer made to Your Honor over there in the Netherlands, I am saying on my own behalf, Mr. Millen's behalf, as counsel to Demark Advisor, that was wrong what the Dutch lawyer said to you, and I'm sorry. I do not know genuinely what kind of jeopardy that would expose Mr. Millen to.
I think it could be narrowed much more than that. I don't think he needs to say all that, at least from what I read it. Seems like to me, he just seems he can admit the Dutch lawyer spoke the law that as it exists in the Dutch law correctly. There's an American way in which this is viewed. There was an issue as to which applied. In my view, the Dutch lawyer should have been able to say that, but the court there believes that I should have informed him of the American law, and he may have already known the American law and chose to do it. And to the extent that was misleading, I apologize. That does not sound like it needs to. Maybe the other side sees it different. Maybe the judges see it differently, but it looks like me it's a very limited, it's much more limited than that.
Do you,
Okay, Mr.
well,
I'm sorry, you go ahead.
I was going to say, do you see, Judge Wynn has suggested, and I guess Judge Keenan too, that there may be informal ways of resolving this whole matter that stop short of an opinion, vacating the contempt order? Do you see a promise in having some informal means of addressing this matter with the district court to make the whole issue go away?
And if I could piggyback on that, do you agree with Mr. Dory's representation here that in the joint appendix is a declaration from Dutch counsel saying there was nothing that would have prevented Mr. Millen from himself filing a statement or an email with the Dutch court? Do you agree with that?
I agree that their Dutch lawyer said from the gallery that Mr. Millen could send an email to the court. I suppose the same way a Dutch lawyer could send this court's public email address. But the words the court uses, both in the correction order and the contempt order, matter. I understand.
Yeah, but I think Judge Wilkinson and Judge Wynn are making excellent points. You know, there's got to be a way to work this out. And it seems to me there's a little bit of standing on righteousness going on here. And you know, I understand your position, but there has to be a way to work this out.
I do want to make sure, the point is well taken. I want to make sure I respond directly to the question that your honors have raised. I don't unfortunately see a informal way to resolve this because he's been held in civil contempt.
I mean, the thought occurs to me, and I think ideally an informal means of resolving this would be a good idea, but the fine district judge, he got the bit in his mouth, and he may, as a matter of sort of pride or whatever, decide that no, I feel like that this has been, that what I did was disregarded and disobeyed and everything. I can see a district judge getting his back up in a situation where there's no formal vacating, well, the Fourth Circuit hasn't issued a formal opinion vacating the contempt order. I mean, I can see a district judge saying, well, if they want to vacate the contempt order, that's fine, but nothing short. Because they have a sense of pride and they want, you know, he may feel that the authority of the court is at stake. I could see a lot of reasons why a district court here would really plant his feet, short of a formal order vacating. So I'm just not sure if the informal mechanism is likely to work. We could give it a chance, but I could see district court saying, well, they haven't vacated the order, it still stands.
I wish there were, Your Honor, and the last sentence I'd leave you with is I want to make sure it is clear that it's not a matter of pride, it is a matter of honor and professional obligations. Mr. Millen is being asked, the words on the page the district court used, to admit that he and somebody else said which is not true. That is not just refusal to apologize. That's a big deal. It would be a big deal to me. It's a big deal to him. Thank you, Your Honors.
Thank you. We'll come down and we'll greet counsel and proceed into our final case. Mr. Brown, we'd be pleased to hear from you, sir.
Thank you, Your Honor. Good morning. May it please the court. My name is Justin Brown, and I'm here on behalf of Stephen Snyder. Your Honors, this is a trial in which the appellant, Mr. Snyder, represented himself pro se while suffering from a neurodegenerative disease. He was denied a jury instruction on his primary defense, and his most important witness, who was central to every aspect of this case, was not allowed to testify in a fulsome manner. Simply put,
It's an unusual case.
it's a highly unusual case.
Was
Your Honor.
was he competent to stand trial?
Yes, Your Honor, he was competent to stand trial. However, it's our position that
Because you could go through all kinds of, if you got a neurological deficit, you got things going on, you got expert testimony, the whole bit on that aspect of it. And I'm just trying to connect that with, can he represent himself in a pro se capacity if he's competent to stand trial?
Right. Well, Your Honor, of course, there are cases in which the district court has not permitted a pro se litigant to represent himself pro se.
What's a district court to do? Because if you had proceeded to trial with a lawyer, then we'd be up here saying, well, I wanted to exercise my right to pro se representation, and you denied me my Faretta rights, so you just put the district court in a position where it's just whipsawed. Because if he says, well, okay, go ahead, you proceed pro se in spite of all the warnings that he's been given, then the district court gets clobbered for allowing him to proceed pro se, as you're doing here. And then if the district court said, no, I'm going to appoint a lawyer, and you're not going to be able to proceed pro se, then the district court gets clobbered for that. And what's a trial judge to do? I mean, other than what was done here.
Well, Your Honor, I think there's a pretty simple answer to that question. The trial court has to make some type of inquiry, some kind of inquiry, any inquiry, but the trial court and the magistrate who handled the Ferretta hearings, they did nothing to inquire about Mr. Snyder's ability to represent himself. There was one point, and as Judge Wynn just said, this was a highly unusual case. But there was one point during pretrial motions where Mr. Snyder had, on a break, had fallen in the bathroom, had been on the floor for 30 to 40 minutes, wasn't able to get up until his standby counsel came in.
But tell me, one thing you didn't put in your open brief, what do you think our standard of review is on this?
Well, we think this should be a de novo standard of review. And the reason for this...
What would that be? It would seem to me it would be a discretionary call on the part of the district judge as to whether he was going to recognize the right or not.
Well, I think the reason for this, and again, it's unique, is you're dealing with a pro se litigant. So to put a burden on him to sort of raise the objection.
Well, we are and we aren't. I mean, this gentleman is an attorney. This is not your usual pro se litigant. This is an attorney, and he actually, from all I can gather, did a pretty decent job of representing himself. He was told about all the liabilities of proceeding pro se. He was, the magistrate judge told him twice, you're running a real risk here. And he says, no, I'm gonna go pro se. And if the district court had denied him the right to proceed pro se, he would have been screaming bloody murder up here that his constitutional right was denied. I mean, it's a no-win situation for a trial court.
Right, Your Honor, what I would suggest, though, is where the magistrate judge fell short is, yes, he continually asked Mr. Snyder, are you sure you want to do this? Are you sure you want to do this? Do you understand the risk?
He insisted he did want to do it.
That's right, but at no point did the magistrate judge inquire as to his ability to do it. He was never questioned about the neurodegenerative disease that he was suffering from. There wasn't a single question about that. There wasn't a single question about whether he was able to manage.
Well, he was competent to stand trial. You've already said that. And by being competent, you now are arguing the court was required to appoint him a counsel. Where does that take us? I mean, because there's so many other pro se defendants, they wouldn't do anywhere near the job here, as Judge Wilkinson said. So what, it would be required in those cases then?
And Your Honor,
there's a difference between could appoint and required to appoint someone under these circumstances, where he's competent to stand trial. You've admitted that right off from the bat. So you can talk about his neurological defects and all the other stuff, but he's competent to stand trial. From the physical perspective and mental perspective, that much to stand trial, he can do so. The question then becomes, if he chooses to represent himself, now is the court required to appoint him a counsel? And I'm not sure that leads you to a de novo review on that question, but proceed.
Well, I understand Your Honor's point that there are challenges here. But what I would suggest is that there is a narrow path. Is he competent to stand trial? Absolutely. We don't dispute that. But there is case law. Indiana versus Edwards is a Supreme Court case, and Frazier L. out of the Fourth Circuit. And those cases recognize that the judge may revoke pro se status.
See the word you just used? May. But you're now saying required.
Okay, and I'm hearing a couple of different things too, because it seems to me you're saying that the Ferretta hearings were incomplete. and that in itself is the basis for reversing the conviction. Is that correct?
Well, what
Or
I'm
not?
saying,
You're saying that the FREDA hearings didn't go far enough? What should the magistrate judges have asked that was not asked?
collectively, the two courts, the district court and the magistrate, they should have at least initiated some type of inquiry. Something.
What are you saying? Should have given them a test on the law? Or what, in other words, you're writing the opinion of the court consistent with your stated position. What did the court do wrong? And when should the court have intervened?
So
At the beginning of trial? At a recess? What point? What point did the court abuse its discretion?
Your Honor, at the point in pretrial motions, when it was revealed to the court that Mr. Snyder was being investigated for having Parkinson's disease, at the point when he had just fallen and been on the floor of the men's room for 30 to 40 minutes until his standby counsel went in and picked him up and brought him back into the courtroom, when he was bleeding from his head and he was bleeding from his arm, I would suggest that was the time when the district court should have asked a question, a simple question. Is this person okay? Is this person able to represent himself? And the record...
He did a pretty good job. I mean, this is not a question of somebody who is incapable of standing trial. He's an attorney, and he wants to represent himself. And if he didn't represent himself, he would be resentful forever after. And said, if I represented myself, I could have gotten an acquittal. And the magistrate judge held not one but two FREDA hearings. I find myself asking Judge Keenan's question about what in the world of the magistrate judge or the district judge to do. And again, you look at the record here. You look at the cross-examination, you look at the closing argument, and it's pretty good.
Your Honor, I would remind the court that he was held in contempt and locked up in jail overnight because the district court found that he was not following instructions, that he wasn't complying with the rules of the court. So were there points when he asked a good question? Of course there were. But there were hundreds, if perhaps 200, 300, 400 sustained objections coming not only from government counsel, but also from the bench. I mean, this was the most combative trial imaginable. Your Honors, I would also like to carve out a little bit of time for another one of our issues. And that specifically is the advice of counsel issue. And this was Snyder's primary defense at trial. And it should come as no surprise that this was his primary defense, because in 2018, initially, the U.S. Attorney's Office had declined to prosecute this case because it concluded that he was acting under advice of counsel. There was a plethora of evidence that he was using counsel, and they were advising him throughout this process.
The problem was they found they didn't fully disclose it to that counsel.
That was the conclusion that the district court reached, but there was a lot of other evidence indicating that he did make a fulsome disclosure.
What did the counsel say?
I'm sorry?
The counsel, the one he's supposed to get the advice, how did he put it?
He said that he had a general understanding of what was going on. He had provided him with a template.
Did he say it had been fully disclosed to him and he had all of the information and therefore I gave him advice based upon that, or he got a general understanding?
That's unfortunately that specific question was never asked of him.
That's the problem. If you go to a lawyer and you get advice, if you don't tell him all the facts, and this lawyer didn't know all the facts. I mean, he made that very clear. I didn't know all this. And then you get advice. He gave advice based upon the facts that were given him, but he was not giving all of the facts or the essential facts to it.
And Your Honor, that was the government's argument, right? This was a factual dispute. The government argued that all of the relevant facts had not been provided to counsel. There's also the defendant's perspective, or the appellant's perspective in this case, where there was a plethora of evidence that he did. He wanted counsel to be included on everything. He wanted counsel to be included on phone calls. He wanted counsel to be there for meetings. The problem and the mistake that the district court judges is that they only viewed the evidence in the light most favorable for the government.
And I'm not trying to be argumentative, but it just seems to me, I don't think he disclosed to him he was trying to run a blackmail scheme against this hospital to get $25 million from him. I don't think he went to counsel and said that, and that's what I want to be able to do, and the counsel says that's okay.
Counsel was aware that as an initial bargaining position, he was seeking $25 million over 10 years.
Personally.
This was a consultancy.
But he was seeking it for himself personally.
That's correct. It was a consultancy that he was going to fulfill.
He didn't tell that lawyer that he was trying to get $25 million for himself personally. In exchange, I won't file suits or bring out some information. That sounds like pure blackmail to me. But I know, at least from just an initial impression as a lawyer to give advice. If a client comes and tells you that, you're probably not going to turn around and says, "Oh, that's okay. You can do it that way."
Your Honor, he not only had one lawyer, he actually had 3 lawyers. The other lawyers, Eric Yaffe and John McNutt, he was consulting on them regarding these issues. He was consulting about them on the demand letter that was initially sent to the hospital. There was all kinds of evidence there, and it was his client, Michelle Sanders, who wanted the consultancy and who suggested the consultancy. But the problem that the district court made...
I thought he was seeking the $25 million for himself.
Your Honor,
not for his client.
that was explained to his lawyers, and they were trying to figure out...
Is that true? I mean, you said his client wanted him to do it. I don't think the client wanted him to go get $25 million for himself.
The client was aware of that figure.
But there was no benefit to the client for him to get $25 million personally.
The client, there was a benefit to the client in that what the client wanted was for this department of the hospital to clean up its act. I mean, that was one of her primary goals, and that was stated very early on in this case in mediation.
Isn't that a jury question?
Your Honor, these are all jury questions. That's the problem with the judge's decision to not give the jury instruction. That's the same as directing a verdict. Basically, the district court directed the verdict on this issue, on the advice of counsel issue, and when it does that, it needs to be...
He didn't direct the verdict, he just said that there wasn't a sufficient evidentiary foundation for the instruction.
Then the court really did give some latitude, allowing him to argue advice of counsel, didn't the court?
I think that, and I'm sorry I'm over my time if I can continue, but I think the Hicks case is instructive on that. When the court doesn't give a jury instruction, it is essentially directing a verdict on that issue, and it can only do that if it's viewed the light in the...
It's not directing a verdict on the issue because you're still able to argue it. You know, Judge Keenan's right. You know, you still have plenty of options to get that. It's not an instruction on nothing.
The judge was standing in the place of the jury and weighing one set of facts against another and choosing the government's side.
That's just ruling on a rather ordinary question we have as to whether the failure to give a specific instruction is an abuse of discretion. And we have these things all the time. Nobody's ever suggested that a declination to give a particular instruction is directing a verdict.
Well,
but at any rate, you've got some rebuttal time, okay?
Thank you, Your Honor.
My colleagues, Jim, you, Barbara, you,
Thank you.
Munoz, happy to hear from you.
Good morning, Your Honors, and may it please the Court. MJ Kirsch Munoz for the United States. In 2018, Mr. Snyder tried to finagle a $25 million personal payment from the University of Maryland medical system. He did so by threatening to unleash a media campaign calculated to destroy the hospital, its transplant program.
What's our standard of review on this issue that's before us?
On the competency issue, Your Honor, that's actually a really great question. I don't believe this court has ever articulated a standard of review with this kind of Edwards challenge. Because, of course, Edwards holds that the Constitution permits interfering with a FRED request for gray area defendants, which suggests an abuse of discretion standard in that kind of case, and may suggest an abuse of discretion standard here as well. But even still, Edwards does not speak directly to the question raised by Mr. Snyder, which is when, if ever, the Constitution requires the court to...
Why wouldn't it be a discretionary call as to whether the individual here should be allowed to proceed pro se or not? Nobody's talking about complete deprivation of a right to counsel, but it's a discretionary call as to whether the defendant is going to be allowed to proceed pro se. How does that get in? How does that transform into de novo review?
Well, Your Honor, I'm certainly not arguing it's de novo. I'm saying at worst, it's abuse of discretion because we still don't know, and again, we don't have to figure this out in this case, but we don't know when the Constitution requires the court to impose counsel on a gray area defendant, which is what Edwards does not say. Edwards says only that a district court may force counsel on a gray area defendant even if he is unwilling. So given the nature of the distinction between that which is constitutionally required and that which is merely constitutionally permitted, the abuse of discretion standard that the Edwards court applied may be even too generous for what's going on here. But I will accept certainly for purposes of this argument that we're operating under abuse of discretion here because Edwards does, of course, confer discretion on a district court in limited circumstances.
Even with that, Mr. Brown acknowledges that the defendant here was competent to state trial. Does it then follow that he is competent to waive his right to counsel?
Yes, Your Honor, that is exactly right. The standard for competency to stand trial and to waive the right to counsel is the same. It's the two-part Dusky standard. And this court held in Bernard and reaffirmed in Ziegler that a district court is not required to do anything more than ensure a defendant's competence under the two-part Dusky standard and, of course, ensure that the waiver of counsel is knowingly and voluntarily made. And of course, the court did exactly that here. It wasn't required, the magistrate judge as well as the district court, was not required at any point to conduct an additional Edwards inquiry, for lack of a better term, to determine whether Mr. Snyder was capable of effectively representing himself. He only needed to be, competent under the Dusky standard, and that resolves this case.
What about the advice of counsel question?
Sure, Your Honor. So I'd like to point out, I think, what Mr. Brown did not say either in his brief or up here at the podium. He has not pointed to any evidence still that his attorneys knew about the tactics that Mr. Snyder employed to obtain the consulting agreement, much less advised him that he could use such tactics. And that alone should close the book on this issue. An attorney can't evaluate whether his client's actions cross a line into extortionate conduct unless the attorney knows both the demand made, which is here the consultancy, the terms of the consultancy, and the threats used to support it. And of course, in this case, that's the negative media.
Judge Wynn hit the point on the head, didn't he? That if you're going to have an advice of counsel defense, you've got to tell counsel all the facts. And the problem here was that the lawyer did not have the kind of facts that enabled him to render him informed advice. And that's a matter of trial management. District court's decision to give or not to give a particular instruction. The district court says There's evidence here that the lawyer knew all that he needed. There's no evidence here that the lawyer knew all he needed to know in order to render competent professional advice. That's the kind of thing we would normally leave to trial court case management.
That's exactly right, Your Honor. And the district court found, quote, certainly there is no evidence that Mr. Graham blessed what Mr. Snyder did during these meetings. And the record very much bears that out. None of his attorneys testified, and there's no record in the evidence, suggesting that they knew the means by which he sought to obtain the consultancy agreement, which again is the threat of a negative media blitz that was actually unconnected to his client's case. Because certainly by the second meeting, the June meeting, he had said, okay, fine, you settle this case with my client for what I think that's worth, between $3 and $5 million, but I want you to pay me separately. I want you to pay me $25 million, or I will unleash this negative press campaign against the hospital. I'll drum up national and local interest in the alleged fraud that the hospital is committing. And that is, I think, pure blackmail. That's the kind of shakedown that I think really distinguishes this case and what Mr. Snyder did here from the SCAD and retainer agreement that was held up as a model by one of his experts at trial. Obviously, in that case, the SCAD and partner was not threatening the company he was seeking to be on retainer with blackmail. And so, Your Honor, I really do think that there's no basis for an advice of counsel instruction. The district court was completely right about that.
Do you have anything further?
I do not, Your Honor. Unless Your Honors have additional questions, we would just ask this court to affirm across the board.
Can't do anything further. We have nothing further. Thank you.
Thank you so much.
Mr. Brown?
Thank you, Your Honor. I would like to just clarify one point that's already come up, and the question of whether Snyder told his lawyers all of the relevant facts pertaining to this. That's a question for the jury to answer. If one were to view the facts of the case in the light most favorable to Mr. Snyder, one could reach the conclusion that he had been fully transparent with his lawyers. In fact, he twice set up a meeting in which Andy Graham met with the plaintiff in the underlying Med-Mal case. So he also attempted to initiate phone calls between Mr. Graham and attorneys for UMMS. And he also attempted to bring Mr. Graham to meetings with UMMS. So if one were to look at those facts, you could reach a conclusion that there was full transparency with his lawyer. And that's the lens from which the district court should have looked at this issue. Any dispute of facts, that's a question for the jury, not for the district court to make. I would like to touch on one other issue, a third issue that we also raised in our briefing, and that was the testimony of Michelle Sanders. She was Mr. Snyder's client. She is the one who, from the outset, requested the consultancy with the hospital. And when she was called as a witness, her testimony was severely limited because every time Mr. Snyder tried to ask her a question, the court allowed her to not answer it based on a non-disclosure agreement that was in the settlement agreement. So what you had in this issue was a conflict between Mr. Snyder's right to present evidence in his own defense and a non-disclosure agreement within that settlement. And the judge never even considered the weight of those two concerns. There was no consideration whatsoever. And what actually happened at the trial was that the witness's lawyer, who was in the gallery, was objecting from the gallery, and the court was deferring to him as to whether Ms. Sanders could have asked a particular or could have answered a particular question.
Okay, but the court wasn't made aware before trial of the non-disclosure agreement, was it?
That's true. I mean, it did
Okay,
come up.
So this sort of landed on the court at the last minute. Does that have an impact on our review?
I think that, again, and that is sort of related to the pro se status of Mr. Snyder. I think if he had been represented by counsel, that might have played out a little bit differently. But I think the fact that the issue came up at the last minute does not alleviate the district court judge's duty to at least weigh those two competing interests, the non-disclosure agreement versus his constitutional right to put on evidence in his own defense.
Well, didn't he get it in? I mean, what other witnesses testified to much of what was there? I mean, what additional testimony was she going to add to this?
Your Honor, there was a lot of things that she would have added that he tried to ask her. She was aware that the department, as a result of this lawsuit, had taken down its promotional videos. She was aware of other remedial measures that the hospital had taken. She was aware that 5 transplant surgeons had been fired from this division as a result of this.
Now, let me understand. How does that apply to extortion?
It goes to Snyder's state of mind.
As a defense?
It goes to the wrongfulness element of extortion. He reasonably believed that there was widespread malpractice and widespread fraud going on at this department.
And then reasonably concluded he could get $25 million to say, I won't tell anybody about it.
It goes to the comments that were made about the economic harm that could be inflicted on the hospital. That if this widespread fraud and malpractice was going on, he could then advertise for clients and presumably get clients, and we see this on TV every day, and that could have generated many, many millions of dollars in damages against the hospital. So what it does is it explains his frame of mind, his basis of knowledge, and it goes to the wrongfulness element of extortion.
So you think ultimately, if you take it in his light, what he was trying to do was legal? From your perspective, you think that's legal? You go in the hospital, you see all these things going on, and so you give me $25 million, you can stop these things, save people tons of money, and that's good. Lawyer walks out with his $25 million, hospital stops it, public's benefited. That's legal.
Your Honor, the figure of, and I'm out of
Just
time.
answer that question. I want to know. And maybe I'm not trying to be absurd about it, but I'm just saying that's basically what happened. You think that's a defense for that?
If there was malpractice and widespread fraud
Yes.
going on inside of that union,
He knows all about it.
and an attorney can initiate an advertising campaign.
But that's not what happened here. What attorney did is walked in there to talk to some people and said, give me $25 million and I will, and you go clean this up and I won't say anything, won't bring actions.
His client specifically asked him to do a consultancy with the hospital. I mean,
Sanders did.
Right, but then when she found out the terms of what he was thinking about, she was opposed to it.
Well, she was made aware of some of the terms, and no deal had been fleshed out. It was still in the negotiating process. So there was no final deal in that respect.
The point was made that Sanders was on the witness stand for an extended period and that your client was able to cross-examine her extensively, and I think the comment was made somewhere that he asked more than 300 questions of Ms. Sanders, so it's not as if she was an absent figure. 300 questions, that's a little bit more than usual cross-examination.
Well, and I would also point out, Your Honor, that there were about 10 questions that were asked of her, which she did not answer under the instruction of her counsel who was sitting in the gallery and she did not answer those because of the non-disclosure agreement.
So you're saying there were 290 questions?
Your Honor, it's not always quantity, sometimes it's quality.
We thank you, sir.
Thank you very much, Your Honors.
We will adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.